morning. All right, it's my understanding that defense is resting, is that correct? All right, I'm not going to bring the jury out just to take them back in. So when after we finish our motions, I'll let you say that, yeah, okay, let's just do it that way. All right, so based on them resting, you have a motion? Yes, sir. And I did receive your memo ahead of time, so I have reviewed that. Okay, I have that, okay. Yes, sir?
I haven't received anything from them. I don't know whether they filed it.
I think it's just going to be oral arguments. Yes, sir.
Good morning, Your Honor. May it please the court. Strike defendant Amber Heard's counterclaims because Ms. Heard has not proven by clear and convincing evidence that Mr. Waldman made the 3 allegedly defamatory statements.
But clear and convincing is not my motion to strike standard.
Understood, Your Honor.
Okay.
And we have cited the standard in our brief.
Thank you.
Moreover, Your Honor, the court should also strike defendant's claim for fees based on Virginia's anti-SLAPP statute, as she is not entitled to immunity under the statute, because we know that the court has carefully reviewed salient points.
Thank you, sir.
Thank you, Your Honor. I would mention, however, Your Honor, that because this is not included in our brief, that there is no whatsoever that Mr. Depp even saw any of the 3 statements that Mr. Waldman made with the counterclaims in this action, which we believe which we believe is relevant to many of the legal standards. And as Your Honor is aware, Ms. Heard had signaled for the past week that she was playing Depp in her case in chief, and it was our anticipation that she would try to fill what we believe is a gaping hole with her proof. Again, there's no record evidence. As Your Honor is aware, the elements of defamation are as follows. 1, publication of 2, an actionable statement with 3, the record. See Tharp versus Sanders, 285 Virginia 476 at 2013. The requisite intent for defamation against a public figure, that is, the statement must be made with knowledge that it was false or with reckless disregard of whether it was false or not. See Sanders v. Harris, Virginia 369 at 372, a 1972 case. See also Jackson v. Hartig, 274 Virginia at 2019. Disregard, as Your Honor is aware, quote, is not measured sufficient evidence to permit the conclusion that the defendant, in fact, entertained serious doubts as to the truth of his publication, unquote. St. Amant versus Thompson, Supreme Court, 727 at 731. Your Honor, the evidence shows not established that Mr. Waldman made the statements with actual malice. Mr. Waldman testified that he conducted extensive investigation, reasonably believed that the 3 statements he made were true. Ms. Heard presented nothing to contradict that undisputed fact. Has no evidence of direct liability, because obviously, Your Honor, we need to talk about direct and vicarious liability, but it bears noting that she has no evidence of direct liability to prove actual malice by Mr. Waldman when making the 3 statements at issue. It is undisputed that malice by Mr. Waldman when making the 3 statements at issue. It is undisputed that Mr. Depp did not claim. Moreover, in order for Mr. Depp to be liable for the conduct of one of his attorneys, there must be some showing that he directed, participated, or otherwise Mr. Waldman to make the statements at issue. There is no such evidence on the record that Mr. Depp directed or otherwise authorized Mr. Waldman to make the at issue in the counterclaims. Indeed, there is no evidence of any communication or coordination between Mr. Depp and Mr. Waldman regarding the counterclaims. For this reason as well, Your Honor, Ms. Heard cannot meet her burden of proving that Mr. Waldman was acting within the scope of his employment as on behalf of Mr. Depp. Again, it bears noting that there's no evidence that Mr. Depp even saw the statements by Mr. Waldman until he was sued, served with the counterclaims more than a year after Mr. Depp filed his complaint, and Ms. Heard lost a series of motions to dismiss that she finally asserted her, most of which have already been dismissed by opinion letter of this court. Whereas here there is no evidence of direct liability, Ms. Heard must rely on a theory of vicarious liability to hold Mr. Depp liable for the actions, or statements rather, of his purported agent, Mr. Waldman. Vicarious liability is by definition, quote, liable person, unquote. So to hold Mr. Depp liable for Mr. Waldman's statements, Ms. Heard must establish that Mr. Waldman himself committed all the elements of defamation. I know the court's familiar with this, so I'll try to run through it quickly. See Parker versus Carillon Clinic, 29, quote, vicarious liability is liability for the tort of another person without first proving that the employee committed, at page 156, which standard Ms. Heard has not met. And Your Honor, we cite a string citation to cases from which we obviously are not binding on the court, but we believe are influential. We presented those to the court for its review. It is important to prove by clear and convincing evidence, or ultimately, to prove, and while it is well settled law in Virginia, as Your Honor has pointed out last week, that an agent's knowledge can be imputed to a principal, and this is the Allen Reels Holbert imputed to an agent. In other words, Mr. Waldman must have made the statements knowing that they were false or with reckless disregard as to whether they were false. Depp's knowledge cannot be imputed to him. There is no evidence in the record that Mr. Waldman knew the counterclaim statements were false. Indeed, Mr. Waldman did not even know or misheard at the time of any of the alleged incidents at issue, and thus had no personal knowledge of what transpired. And this is reflected in or misheard at the time of any of the alleged incidents at issue, and thus had no personal knowledge of what transpired. And this is reflected in the trial transcript that Mr. met Mr. Depp first in October of 2016, long after the fact. Nor is there any evidence in the record that Mr. Waldman subjectively entertained about the falsity of the counterclaim statements. Quite the opposite. The evidence shows, and it's unrebutted, I believe, and will to his dying day, that Ms. Heard's claim of abuse were patently false. Mr. Waldman testified at length about claims of abuse. See the transcript at page 6008 through 6012, and I won't run through all of that. Sir Science and Haddon were called to the penthouse on May 21, 2016, and saw witnesses who have testified in various forms at various times that there were no injuries to her face whatsoever between May 21st and May 27th, with her publicist, her lawyer, her former best friend who no longer speaks with her, for a no-notice ex parte TRO. Some of them has cited, they include Laura Devenir, Melanie Inglesis, who, as Your Honor recalls, was Ms. Heard's makeup artist, who discussed professional or personal association with Ms. Heard, Samantha McMillan, Hilda Vargas, Isaac Baruch, Romero, and Brandon Patterson, just to name a few. No reasonable jury could find that Mr. Waldman acted defamatory statements. He was not present, nothing he did on behalf of Mr. Depp. Ms. Heard cannot possibly claim must fail. 2, Mr. Waldman is an independent contractor, not an employee. It is axiomatic, Your Honor, that a person who is a contractor is a person who is engaged to produce a specific result, but who is not subject to the control of the employer principal as to the way to bring about. See Atkinson versus Sachno, 261 Virginia 378. A client in connection with litigation is an independent contractor. C. King versus Dalton, 890 Virginia, 1995, where Judge Ellis, a legendary jurist known by all Virginia practitioners, held that, quote, an attorney working with a client is nonetheless an independent contractor and is not an employee of the client corporation. In that case, the employer was the corporation, but this applies when it's an individual like Mr. Depp. That was Mr. Waldman's role, or to try to obtain specific results. But they does. See Virginia State Bar Professional Guidelines, Rule 1:2 and 2.1. And just to quote 2.1, in representing a client, exercise independent professional judgment, unquote. Mr. Waldman is, as a matter, responsible for any alleged tort by his attorney, particularly for statements about which he was unaware until testified, and it's unrebutted, that he has his own law firm. He's not an employee of Mr. Depp. Loan out companies have issued him a W-2, and Mr. Waldman provides legal services to clients other than, in addition to page 6,000, our claim should be stricken, is that Mr. Waldman's statements were protected opinion. And I won't run through all of that, but very briefly, are non-actionable expressions of opinion entitled to protection under the First Amendment. See case from the United States Supreme Court. See Virginia 83, a 2015 case, noting that where, quote, all sides of the issue, as well as the rationale for the speaker's view, the assertion of deceit reasonably could be understood only as the speaker's personal conclusion, unquote, and finding in an accused opinion. In context, Your Honor, any reporter or any reasonable reader would understand and expect a lawyer associated with Mr. Depp was to challenge Ms. Heard's version of the inherently controversial events of the Mr. Depp. And Your Honor will remember the context of these quotes that were in a British tabloid where Mr. Waldman's statements were buried well, points of view were clearly expressed, and Mr. Waldman was clearly identified not as an independent expert on the U.S. Constitution, but as attorneys. C. Chavez, 230 Virginia 112, stated recipient of such a claim, i.e., any reader of the British tabloid, as a relative statement of opinion grounded upon the speaker's obvious of and belief in Mr. Depp. Finally, Your Honor, and for the rest, ultimately about events that he never claims to have witnessed. And there was no to the second about events that he never claims to have witnessed. And there was no doubt about that. To the second part of the argument, which will be more abridged, Ms. 8.01-223.2, which is, as Your Honor well knows, provides in part, quote, the immunity provided by this section shall not apply false or with reckless disregard for whether they are false. Here, in addition to Mr. Depp's testimony, several witnesses have testified they never witnessed Mr. Depp abuse Ms. Heard. They never witnessed Mr. Depp abuse Ms. Heard. And B, that they observed Ms. Heard without any injuries, marks, bruising, swelling, etc., during periods when Ms. Heard claimed to have injuries. Such witnesses include, but are not limited to, Isaac Baruch, Kate James, Dr. David Kipper, Nurse Debbie Lloyd, former U.S. Marine Starling Jenkins. Ms. Heard's request for anti-SLAPP immunity should be stricken, and even if viewed facts as to that, the anti-SLAPP immunity does not apply because the defamatory implication of Ms. Heard's statements to a matter of public concern, as is required under the statute. As has become quite clear, Your Honor, Mr. Depp is not suing about any of the policy commentary made by the ACLU when it drafted the op-ed, and Ms. Hurd put her name to it, were directed at him. He has no issue with women's rights. He supports women's rights. In fact, he was the one, Your Honor, as Your Honor knows, who made that first $100,000 contribution to the ACLU. Also, to the CHLA.
Your Honor, at this point, I'm going to object. Mr. Chu has largely just read his brief and confined. He's now directing his arguments to something other than what's at issue here, and I would object to risk the jury being influenced.
Or the three statements. And it's very clear, despite the pious opening statement that about the First Amendment, that of Terrence Doherty and the emails that were admitted as exhibits of Terrence Doherty and the email exhibits, that the ACLU and Ms. Hurd were conspiring to Mr. Depp, because otherwise nobody had any interest in film of any significance in terms of popularity is risible, and that is not why as generally analyzed by the courts, a matter of public concern is one which relates to, quote, a matter of political, social, or unity, unquote, as opposed to a matter of only, quote, personal interest, unquote. That's Connick versus Myers, 461 U.S. 138, page 146. Instead, the defamatory grievances between Mr. Depp and Ms. Hurd, which does not rise to the level of a matter of public concern with broader implications for society beyond the two, any more than Mr. Waldman's statements. I mean, adding the gloss of public policy, the statements that relate to public policy, but those are not at issue here. Mr. Depp agrees with those statements. Very cleverly put in to make it clear the implication that it was about Mr. Depp. They had lawyers to be as clever about this as possible. And Your Honor remembers the testimony of Mr. Doherty about the consternation that USA Today and everybody else who think now that we have the undisputed evidence exactly what they were doing, Your Honor. And he referred to testimony of a woman at the ACLU who said she had nightmares about Ms. Hurd, and he expressed no concern about it. They knew about the donations. The donations became pledges, but we have evidence that she refused to sign the pledge card. So she's caught either way. Simply stated, Your Honor, Depp is not suing Ms. Hurd for making statements about society in general. I think that's very clear from the record evidence. And forever tarnishing his good name. And that is anti-SLAPP statute is not applicable. And based on the foregoing, Your Honor, Mr. Depp respectfully submits that is not applicable. And based on the foregoing, Your Honor, Mr. Depp respectfully submits that the court should grant plaintiff's motion to strike the counterclaims, saying that she is immune under the anti-SLAPP statute. Thank you very much, Your Honor.
Thank you, sir. Yes, sir.
As Your Honor knows, the trial court is required to accept as true all the evidence favorable to Amber at this point, as well as any reasonable inference a jury might draw therefrom counterclaim. That's the correct standard here. I'll address the actual malice argument first, the agency argument. Your Honor, there's plenty of evidence in the record from which the jury could determine that Mr. Waldman, he made those statements. The statements referred to him as Mr. Depp's attorney. As Your Honor ruled on Friday, Mr. Waldman testified that he's been Mr. Depp's attorney since 2016. He freely admitted speaking to the press on Mr. Depp's behalf, and he refused to answer a question after. We can't use that as a sword now. Mr. Chu puts a lot of emphasis on the fact that Mr. Depp allegedly didn't see the comments that were made that are the subject of the count. Whether he saw them or not is not the standard for agency. There's also evidence that Mr. Depp met with the Daily Mail with Mr. Waldman prior to the being made and released. I believe that was in February of 2020, just 2 months prior. Mr. Waldman also concocted a story that Amber was being investigated for perjury by filing a perjury complaint against her with the LAPD. He disregarded any evidence that he didn't believe would fit in his narrative, that would fit in this story that he was speaking about on behalf of Mr. Depp. Lost the UK proceeding after Mr. Depp was ruled to be a wife beater by the court in the UK proceeding. The court there found him to be a wife beater. Mr. Waldman tabloid to run a story claiming that Amber was being investigated for perjury, which simply wasn't true. He walked into the LAPD, filed a complaint for perjury against Ms. Heard, found him to follow the two-source rule, and then he had let the world believe that the LAPD was investigating Ms. Heard for perjury. That's a shameful and a sickening example, Your Honor, of the lengths that Mr. Waldman would go to smear and to defame Amber Heard, and that continued in the three statements in the counterclaim. Your Honor has heard evidence, I won't go through all the evidence, but Your Honor's heard evidence traced the negative hashtags toward Amber Heard online associated with those defamatory statements, and noted the staggeringly high number of them that were associated with Mr. Waldman. Unstable relationship in Virginia, Your Honor, when Mr. Waldman made those statements, he was standing in the shoes of Mr. Depp. They are one and the same for the purposes of those statements. As you're on Friday, Mr. Waldman made these statements with actual malice. There's plenty of evidence from which the jury could infer that. And his own, both from the actual malice from Mr. Depp and Mr. Waldman's own reckless didn't support Mr. Depp, and his attempts to manufacture false evidence that did. As Your Honor found in the hearing, I believe it was on March 24th, after Your Honor made Mr. Depp's motion for summary judgment, Your Honor said, as to malice, a fact finder could reasonably conclude that Mr. Waldman made the statements with malice because Mr. Waldman has no. Your Honor said, as to malice, a fact finder could reasonably conclude that Mr. Waldman made the statements with malice because Mr. Waldman has no personal knowledge of the party's merit issue. Nothing in this case has changed that. If anything, the evidence has only made it more clear that that is an inference that the jury can and we believe will find. So there's no basis to grant a motion to strike on this agency argument, on the actual malice argument. The evidence shows that not only was Mr. Waldman Mr. Depp's agent, but that the two of them accused Amber of creating a hoax and falsify evidence that they believed supported their theory and what they wanted to achieve. As Your Honor well knows, as Your Honor well knows too, I won't go through all the law. And malice can be inferred through circumstantial evidence. There's plenty of evidence in the record from which the jury could infer those. Moving on, Your Honor, to the independent contractor, the court's already evidence in the record from which the jury could infer those. Moving on, Your Honor, to the independent contractor, the court's already rejected this argument. Client have a principal-agent relationship and rejected this argument. Client have a principal-agent relationship, and as Your Honor said on Friday, there's no evidence in this case of anything otherwise. As to the argument that the counterclaim statements are statements, the court has already found twice that they are not statements of opinion, both on January 4th, 2021, in its opinion letter denying Mr. Depp's demur as to the counts, and at the motion for summary judgment hearing in March of this year. As the anti-SLAPP argument, the court again has already ruled at the March opinion that the statements are as a matter of law regarding matters of public opinion. The court has already ruled that. Therefore, the only remaining issue for anti-met, as we discussed on Friday, the intent element of immunity is substantially the same as the actual malice standard, which the evidence in this case easily allows a jury to end in favor of Ms. Heard on that. I won't go through the litany of evidence that supports that Mr. Depp is an abuser here, but I'll touch on a few things that relate to Mr. Chu's argument. Chu was totally misrepresenting Mr. Doherty's testimony. There's not a single piece of evidence, Your Honor, in this case suggesting that Ms. Heard and the ACLU were somehow conspiring to achieve a defamatory implication. That's simply not what Mr. Doherty said. Mr. Chu's feel free to argue that to the jury, but that's not what his testimony reflects. Your Honor, there's also adduced both in Mr. Depp's claim and in Ms. Heard's counterclaim that show that absolutely that the counterclaim statements are 100% false. There was no hoax. He is an abuser who abused Ms. Heard. She did not conspire with her friends to create a hoax. She did not create a hoax herself. And just very briefly, Some of the evidence that's come up, right, Your Honor, that Mr. Chu conveniently disregards in his brief are the testimony of Rocky Pennington, the testimony of Josh Drew, the testimony of Elizabeth Mars, all of whom completely corroborate 21st, 2016. The testimony of Melanie Iglesias, who testified that she covered Miss Heard's bruises with makeup right after the December incident, that provided ample testimony to support Tillett Wright. He ignores the evidence of Whitney Enriquez. All of these witnesses and others have testified abuse, verbal abuse, Your Honor. Mr. Depp's own writings, recordings, pictures, and videos confirm that. The list goes on. There's abundant evidence in the record, Your Honor, from which we believe will find that Ms. Heard on March 24th, 2021, she would be entitled to anti-SLAPP immunity, which would permit her to ask the court permit her to ask the court to award attorney's fees against Mr. Depp. So answer any questions the court has.
That's
but
fine.
that
Thank you,
covers
sir.
it. Thank you.
All right. Yes, sir.
Your Honor, I will be brief in deference to the court's time and the jury's time. What Warren said about Mr. Waldman's allegedly going to the LAPD about perjury is a complete non sequitur. If they thought that that were something, they could have included it in their counterclaims. They included everything else but the kitchen sink, and most of it was thrown out. There was nothing in there about Mr. Waldman going to. That is a very clear non sequitur, red herring distraction. Number two, when Your Honor ruled on summary judgment on the issue, Your Honor was dealing with a different standard and a different evidentiary record. At that time, Mr. Waldman had not testified, which is material. Mr. Waldman has now, for purposes of trial, we have his trial testimony. It's very clear that he did not act with actual malice. They didn't even argue that. So that's pretty clear. And again, this is consistent. The third point is that it's all, they didn't sue Mr. Waldman on the three statements. They didn't try to fill the hole. They've been telling us for a week that they're going to call Mr. Depp to try to fill the hole in their counterclaims. And it's very consistent with the game playing. Let's go into court after the police have found no problem and after those who had no relationship with each other said there are no visible marks. Let's not give Mr. Depp's lawyer the required 24-hour notice before the TRO. Let's march into court with our lawyer, with our best friend who no longer talks to her. Let's get a TRO. And when the Me Too folks say, why are you taking $7 million from an abuser? They said, I didn't take money from the abuser. Well, they didn't. I don't think anybody should feel bad about them stiffing the ACLU, given what the ACLU did in this case, which is a monstrosity. But she did stiff. It is gamesmanship. And that's what she's doing here today. But the law is the law to fill their burden with respect to the counter. There is virtually no nexus between Mr. Depp and Mr. Waldman as to these statements at issue, except for the fact that he is an attorney, and that is not sufficient. In a case even established that Mr. Depp was aware of these statements. And they knew that Depp, a man, was saying to a woman, oh, woman up. I only hit you, I didn't punch you. And when it was chilling, when she warned him, you go tell a judge, you go tell a jury that you, a man, were abused. See if they're going to believe that. Your Honor, and Mr. Rottenborn makes an excellent point with which I agree, which was that with respect to each of the printed these, well within articles that had both sides represented, it's going to be forwarding their client's point of view. Mr. Waldman is not the only attorney who has spoken out. Robbie Kaplan, who was an attorney. So Ms. Heard started out with Eric George. He made comments to the press.
Objection, Your Honor. Again, this is so much further beyond what Your Honor
is that Mr. George made statements supporting Ms. Heard's position. Ms. Kaplan made on the merits, and so did Mr. Waldman. But everybody knows when reading those that the court should grant the motion to strike, or in light of the fact that Mr. Depp may reappear, at the very least, take these motions under advisement until the close of.
Thank you, sir. All right, in this matter, I've reviewed all the defendant's evidence as to her counterclaim, and I've considered the arguments of her counsel and plaintiff's counsel. First, to address a few issues that I believe, and that's as to the slap defense. The slap defense is just that, it's a defense, so it's really not considered an motion to strike. Having said that, we went down that legal road on Friday as far as the jury instructions. In this particular case, if the plaintiff prevails, it must be with actual malice. Therefore, if it's with actual malice, immunity does not apply under that statute. So, options that we have. As to independent contractor, again, I think it's outside the motion to strike. However, Mr. Waldman was plaintiff's attorney since 2016, before the initiation of his evidence that Mr. Waldman had a certain role during the prior divorce proceedings in the UK case. Additionally, there is evidence that shows his legal representation was broader than just a limited litigation as an attorney as an independent contractor. So the only evidence in this case to this point is that Mr. Waldman was an agent to Mr. Depp, and that is the basis to weigh the motion to strike. As far as the opinion, again, I think that is outside the motion to strike. The opinions argument, the court, again, I think that is outside the motion to strike. The opinions argument, the court has already ruled on this matter as to the three statements that are at issue in the counterclaim, ruled that argument will not be part of the motion to strike. So when assessing a motion to strike, the court accepts the favorable evidence adduced as true towards the non-moving party. The court cannot reject to the non-moving party unless it would defy logic and common sense. When there is any doubt and question, the court should overrule a motion to strike. Agency may be inferred from the conduct of the parties and from circumstances. When there is no direct evidence, circumstances may, and usually are, relied upon to determine whether an agency relationship exists. A principal is liable for the tortious acts of his agent if the agent was business and acting within the scope of his agency. If an agent's tortious act arises from their agency relationship, is enacted in part to service the principal can be held liable for the tort. Defamation. Besides demonstrating the agency relationship, the defendant must prove Mr. Waldman public. As to agency, Mr. Waldman was plaintiff's attorney at the time of the alleged defamatory statements were made. Mr. Waldman does not deny this, and neither does the plaintiff. Moreover, Mr. Waldman made the alleged defendant during the proceedings of this action and interacted with the defendant once the statements were made while still representing the plaintiff. Taking the surrounding circumstances as a whole, an agency relationship can be inferred, and until of evidence regarding agency must be turned over to the jury. In addition, the jury may infer that Mr. Waldman made these specific statements to a third party to service plaintiff by portraying defendant as litigant in a negative light. It is not disputed that Mr. Waldman published statements and that there is a question as to whether statements are false, and both parties disagree and have presented conflicting evidence. As to actual malice, Mr. Waldman made the counterclaim statements after he met with his client. In addition, there is evidence the plaintiff was with Mr. Waldman at a meeting in February 2020 with the Daily Mail Online. He met with Mr. Waldman where he threw the paper containing the counterclaim statements within them. Consequently, there is more than a scintilla of evidence that a reasonable juror may infer Mr. Waldman made the counterclaim statements while reckless disregard for their truth. It is not my role to measure the veracity or weight of the evidence. The Fourth Circuit and the Virginia Supreme Court have made it crystal clear that actual malice is a question for the fact finder. So therefore, the plaintiff. Thank you. Is there any other preliminary matters before the jury?
Yes, Your Honor.
Okay. All right, are we ready for the jury then? Yes. Okay. Good morning, ladies and gentlemen. I apologize, we had a few housekeeping care of, but thank you. You can have your seat. All right, your next witness.
Your Honor, on behalf of defendant and counter...
Hamada of Warner Brothers.
All right, Mr. Hamada. Okay, well,
I apologize, I should have provided notice.
that's all right.
Thank you, Your Honor.
If we could get the, yeah.
Hamada, do you work for Warner Brothers Entertainment, Inc.?
Yes, I do.
In what capacity?
My title is President of DC-based film productions for Warner Brothers.
To prepare to testify for Warner Brothers as to topics 2 through 18.
I did not do anything to prepare with the attorneys.
Did Warner Brothers have a contract with Amber Heard to perform in Aquaman 2?
Yes, there was a agreement for her for Aquaman 2.
Do you know what it is?
It looks like a standard contract between a studio.
And which actor was involved in
Aquaman and its sequels.
Which studio contracted with Amber Heard?
Warner Brothers.
When did you, president of DC,
At the beginning,
ever released by Warner Brothers from the Aquaman 2 contract? From her Aquaman 2 contract on or about February 22, 2021?
no.
Was Ms. Heard ever rehired by Warner Brothers? Did Ms. Why not?
As a rule, as a company, we go through a lot of trouble when we make our deals with our actors, when we get options on them for subsequent movies, and negotiating every deal with the understanding that people come in and make these deals and they have an understanding that there will be options and that there is a deal in place.
But did Warner Brothers at any point in time reduce Heard's role in Aquaman 2?
The role in the film the size of the role in the film that she has which would have happened in 2018, I would say.
Well,
So and from there, beyond normal development, the role the character story was sort of what it was from the beginning.
was her role ever reduced?
Stages of the development of the script, the movie was built around the character of Arthur and the character of Orm, Arthur being Jason Momoa and Orm being Patrick Wilson, the two co-leads of the movie.
Did Warner Brothers ever plan to portray Ms. Heard as the co-lead in Aquaman 2?
Was pitched as a buddy comedy between Jason Momoa and Patrick Wilson.
Was Ms. Heard cast in Aquaman? Was Ms. Heard cast in Aquaman 2?
Yes, she was.
Was Ms. Heard paid for her services in Aquaman? Was Ms. Heard paid for her services in Aquaman 2?
Yes.
Was her compensation for anything said by Johnny Depp?
No.
Was her compensation for Aquaman affected by anything said by Adam Waldman?
No.
Was her compensation for Aquaman 2 affected by anything representing Johnny Depp?
No.
Was there any delay in Warner Brothers exercising the option to cast Ms. Heard in Aquaman 2?
Yes, there was.
How long a delay was there?
I don't know, probably weeks.
What was the call?
There were conversations about potentially recasting Juan.
Did Warner Brothers believe that those concerns were legitimate?
Yeah, I mean, I had no reason not to believe the director and the producer of the movie.
You are testifying today as a representative of Warner, correct?
Yes, I am.
What, if any, creative casting Amber Heard as Mira in Aquaman 2?
It was the concerns that were brought up at the wrap of the first movie, production of the first chemistry. You know, I think editorially they were able to make that relationship work in the first movie, but there was a concern that it took a lot of effort to get casting, finding someone who had better, more natural chemistry with Jason Momoa and move forward that way.
Did Warner Brothers take any steps to audition other actresses for the role of Mira in Aquaman 2?
No, we did not.
Other than the concerns about chemistry you testified about, was there any other reason?
No, it was all concerns about whether she was the right bit of casting for the movie.
Ms. Heard's dispute with Johnny Depp have in Warner Brothers delay picking up Ms. Heard for Aquaman 2?
There was none from our end.
At any was Warner Brothers considering paying Ms. Heard more contract you previously identified?
No, as I said, we were determined to hold our actors to their option agreements.
Would Warner Brothers have paid Ms. Heard more money on Aquaman if it had picked up her option earlier?
No.
Of history through today, did Warner Brothers ever release Ms. Heard from the Aquaman 2 contract?
No.
At any point in time from the beginning of history to today?
No, because we just picked up her option. No, it would have been the same time that I was having those conversations with Peter Safran.
So
in 2020.
Did you speak with Zack Snyder or Amber Heard on Aquaman 2?
No. I've not had any conversations with Zack Snyder. No.
Have you ever spoken with Jason Momoa about any issues relating to did you speak with Jason Momoa?
Part of my role is I read all the drafts of the scripts as they come in.
When was the first script for Aquaman 2?
Oh, boy. I cannot tell you. Probably
The script had been written by
the script.
All right. What, if anything, did Rob Cowan say to you about chemistry? What specifically about the chemistry between Jason Momoa? About the chemistry between Jason Momoa?
Jates did not have chemistry, and that it's sort of movie magic and editorial, the ability to sort of put performances together, and with the magic of, you know, a great score and a great score and how you play. You can fabricate sort of that chemistry. And so I think at the end of the day, I think if you watch the movie, they look like they had great chemistry. But I just know that it took a lot of effort to get there. Sometimes you don't. Sometimes it's very easy. You just put the characters on the screen together and they work. And sometimes it's harder. And so,
can you give me anything that was with Amber Heard and Jason Momoa that was difficult for the chemistry?
No, because it's like what makes a movie star a movie star. Like you know it when you see it, and it wasn't there.
Now, you've used the term fabricated a number of times. What did you do to fabricate the chemistry between Amber Heard?
A good editor and a good filmmaker can pick the right takes. He can make a happy scene filler, can pick the right takes, can pick the right moments, and put scenes together. Again, score is a big, the music in a scene. You can make a happy scene feel sadder or a sad scene feel happier, design music, etc.
What do you mean by fabricating, though? I mean, were they literally falsifying, or were they just picking the best and picking the best looks because that's their job and that's what you do on every scene?
That is what we do in post-production. That's what filmmakers do. They on any production, you're doing that. You're putting performances together. Sometimes it's easier than, but they're able to. James Wan and the editor were able to get it to
combinations together to make the most successful production.
Absolutely.
I'll tell you what has been marked as exhibit number 5. It's AL message exchange between James Wan and Amber Heard, and you mentioned James Wan, and James is texting to Amber on August 25, 2018. You rated really high with the audience, exclamation mark. Do you see that?
Yes.
This is August 25, 2018. What's going on August 25, 2018 that would cause the director to send a text message?
That'd be a test screening. So during our post-production of movie, we test the movie with an audience, and the audience tells us what they liked and what they didn't like. And so that's what he's referring to there.
Amber Heard, correct?
Yes, she did. She tested well.
It hit $1 billion, is that correct?
Yeah.
To Amber's representatives that Warner Brothers was considering not exercising her option.
Yeah, probably in the sense of we had the conversations. Recall, we had that's where Peter Safran offered to reach out to the agent and express which direction.
That says between Amber Heard and Jason Momoa came back and James Wan came back, you were guaranteeing that Amber Heard would play Mira, correct?
That's correct.
Okay. And Jason Momoa negotiate a different compensation. Highest grossing DC film ever for Warner Brothers, was it not?
Yes, it was.
And what, if any...
My understanding is actually the production went very smoothly.
All right, thank you. Your next witness.
Your Honor, we call Dr. Colburn next, but I know we have a preliminary matter that we need to deal with briefly.
do not discuss the case and do not talk to anybody, okay? Do not do any outside research. Sorry, that was the same thing. Take a break. All right. And if the doctor testifies, then is that WebEx? Yes. Okay, so I'll get that set up too while we take the break as well. All right. All right. We'll go ahead, okay? Thank you.
All right.
Okay, approach. Ms. Myers. Ms. Myers. All right, yes. Are we ready for the jury? Sir, can you hear me? All right. I'm just trying to get you on the big screen. We're waiting for the jury. Just give us a minute, okay, sir?
Thank you.
Seated. All right, your next witness.
We called Dr.
I
Colbert.
would just object that Dr. Culver appears to have a stack of documents right in front of him.
All right, sir, you can put your hand down, and any documents you have, if you could put them away and just testify from your memory, okay, sir? Thank you.
Thank you, Your Honor.
All right, your question?
Good morning.
Colbert.
And what is your profession?
Been in practice for 26 years
Where do you currently work?
when he had injured his hand.
When did Mr. Depp become your patient?
Sometime in March of 2000,
And what type of treatment did you provide to Mr. Depp? And what type of treatment did you provide to Mr. Depp?
he had a fracture of his finger with soft reconstructed his finger.
When did you perform,
20th of 2015.
and what was involved in that surgery, just briefly?
Putting or skin graft, restore some of the soft tissue loss that he had, and then also putting a pin in because he had a displaced loss that he had, and then also putting a pin in.
Immediately after that surgery. Audio cut out a little bit. Could you please repeat your answer?
Distal phalanx.
And what type of cast was on Mr. Depp's hand after you performed? Can you please describe to the jury what it was?
So, I believe in Mr. Depp's case, it was like the two fingers. I think the cluster on the top and on the bottom that goes more bulkier splint. Index finger free, and his thumb free, but the other fingers were probably not being able to move.
How long was the pin in Mr. Depp's finger?
About 11.
And how was the pin removed?
It was removed under local anesthesia in my office.
Mr. Depp for his hand injury.
For several mad injury, it required a few more little office procedures to clean up the tissue, a few more little office until it finally completely healed.
Do you recall when the infection? When was the last time that you saw Mr. Depp? When was the last time that you spoke to Mr. Depp?
After surgery on March 20th, 2015.
Sometimes it's called half a cast or a soft cast, something like that.
And plaster of Paris hardens like a cast does, correct? Goes around your whole hand. It's just as hard as a cast, just as hard as any other cast, correct?
Correct.
Mr. Depp could have 400, please. This has been admitted, Your Honor.
All right.
Your Honor.
All right.
To just scroll through these pictures, and I'd ask you to take a look at them.
Your Honor, I'm going to object for lack of this.
Clear and evidence. Thank you.
Michelle, if you could go back up to that, stop right there. Him from doing this damage to Miss Heard's closet on March 23rd, 2015.
Unavailable. So.
Dr. Colbert, how many fingers were in the plaster portion of Mr. Depp's cast?
I believe 2 or 3, at least 2 were, and the third one and the fourth one.
Why did you call it a soft cast?
And because you allow for swelling, so there's plaster to protect the fracture, so there's to it.
And where are those soft?
Soft, so that the fingers can swell after the surgery.
Could Mr. Depp have hit someone with the hand that had the cast on it?
He could have hit someone with it. It probably would have injured, damaged the cast.
Any damage to Mr. Depp's cast?
Comes to mind.
Could Mr. Depp form a fist with the cast on? Thank you, Dr. Colbert.
All right. Thank you, sir. That concludes your testimony. Thank you. All right. Thank you, sir. That concludes your testimony. Thank you. All right. Your next witness.
Plaintiff calls Richard Marks, Your Honor.
Hold on. Hold on. Just give us a second. No, sir, you've already, just remind that you're still under oath. Okay, sir? All right. Good morning, sir. All right. Yes, ma'am.
Thank you, Your Honor. Welcome back, Mr. Marks. Previously, but would you just briefly remind the jury who you are?
I'm Richard Marks, and every day for productions and for individuals, I'm in the trenches negotiating and much distinguished from the other side's expert who is not.
And are you familiar with the testimony of Catherine Arnold in this matter?
Yes.
Have you been asked to? And generally, what are those opinions?
Well, my opinions are that she's very slick, not an expert in deal making.
Are you familiar with Ms. Arnold's opinion that it's customary for an actor?
Yes, I heard that opinion.
And are you also familiar with her testimony that under those circumstances, an actor will renegotiate a 50 to 1? Do you agree with those opinions?
Absolutely not.
Why not, sir?
Well, and that's an agreement. Let's say for 10 actors the next morning at 9, and you have to fast so that if they're chosen for the part, and you negotiate the first movie. And normally, if they get, if you will, they get the part, normally their salary is, in this case, Ms. Heard's first salary when she got the part, make a next movie, they could recast her, they had no obligation, more than double her salary, like 2.25 times to get to the $1 million. So on a series, say, they go, and they have 5 options. They go up in increments of 5%, 10%, 20%. in a test option agreement.
The test part in a test option agreement.
Be offered the actors that they would be locked up for potentially 4 movies at very lucrative increase, $1 million. Aquaman 2, she gets to $2 million on a normal career. Well, I think what happened in this case was customary for negotiation of multi-picture deals. You assume more than double her salary as you assume succession, if you will, for the 3rd movie. And she's idiosyncratic.
Arnold's opinion that Ms. Heard's salary for Aquaman 2 could have been renegotiated to around...
That would now be Walter Hamada, who is the president. Ms. Arnold, for some substance, says, well, Jason Momoa got to do it, but she doesn't give us any of the details. Was in a movie before the Justice League. He played Aquaman in a movie not with movie. So he had a history before the first movie with Amber Heard. He played Aquaman. It's unsupported that he renegotiated. We're not sure. And you want that star in more movies. You may renegotiate for the last option if you'll give us 3 more options. It's a give and take. And then I think yesterday she said, and the other actors renegotiated thing, except she's asking you just to believe her.
That Ms. Arnold's opined that, but for the alleged, some of the components of that, one by one with you, Mr. Marks. Are you familiar with her testimony that...
Well, again, in Aquaman 2, $2 million. What Ms. Arnold is saying is, oh, she should have worked reasons to negotiate. They weren't here in this case. 4 or 5 movies, every actor has a quiver full of quotes. Journey, their lowest quote might be for the that those are also those type of movies playing another character moment. Her star is born cast, but if it's true, star and to sign them up. And we have stars born phenomena didn't happen. Ms. Heard, but that's 5 times less. Prove it or give us facts and episodes. He played Conan the Barbarian.
Some of those issues in a moment, but I want to take you back of whether Aquaman 2 was the last.
As a 4th option for Aquaman 3 or another movie's salary again. So it's in success, and that assumes that they recast.
Deals, such as the one she had with L'Oreal.
I'm aware of that testimony.
Do you agree with that opinion?
No.
Why not?
Again, this is a business. We didn't, after the Ms. Heard, during Daily Mail, I believe it was, we didn't see those endorsements coming to her. They had endorsement deals, but she doesn't show you what I call uncomparable actors, but she's making the comparison. She's saying, well, they had all these deals, why was later? And I guess my of this stars born moment.
Do you have an opinion about Ms. Arnold's testimony that Ms. Heard would have made $1 million following her A Star is Born moment?
Yes, I heard it. Amber Heard got that role. She got her salary doubled for Aquaman 1 to $1 million. Would translate into, she'd get that for each episode of a series. We know what she got for a series. She got a series 18 before spring of from somewhere in a glib way to get $1 million for a series episode. In fact, her only series is the 200,000. And if you look, Jason Momoa, if you were to believe, so if you're to believe that, Jason Momoa has had a series with again, there's not a...
Of the option part of that agreement.
They don't have to do any. They can recast the superhero role, you just have to think of how many actors have played Batman or Superman. And indeed, since there's no contract, they only have a choice. Who knows what the negotiation would be, but it's
An option agreement.
well, the alternative is the option, then it becomes, for that picture, an agreement like others in Hollywood. You're hired to play the role. In an option agreement, once they exercise the option, for that movie, it becomes a guarantee.
From her Aquaman 2 contract and then subsequent contracts?
No.
Why not?
President of the studio say, you either exercise your option or you bring. And in my opinion, different rules apply to it.
Options?
No, just you play no card before it's time, and basically saying that there was this.
That's fine.
It's the same thing to say that you were.
Go ahead, sir.
Closed doors, because it can't help your relationship with quite a bit of candor under oath, and he was telling the truth, but it wouldn't.
Say something about not using an actor again in a franchise?
Yes, to pay the actor, but not play them. Go home, we're recasting. In that situation, pay off the actor, that's normally commented on. That becomes a bit of information.
Bird's contract with Warner Brothers for the Aquaman movies. Bird's contract with Warner Brothers for the Aquaman movies.
Oh, yeah. Miss Heard's contract, she still have a right to
Momoa, Gal Gadot, Zendaya, Ana de Armas, and Chris Pine.
Even Miss Heard's agent, Jessica Kay.
Was in testimony that was played in court earlier this week.
I mean, that's not what she testified to. I mean, he's characterizing testimony that was from days ago, and I don't even think she testified to that, Your Honor.
Overruled. You may continue, Mr. Brooks.
Gal Gadot was Wonder Woman. Zendaya has been working on just by one name. Ana de Armas, it was as a nude poster. She's been an ensemble piece, Knives Out. These are not comparable. Oh, who's the most non-comparable because of his history and his career. But what he renegotiated to, what he earned. She didn't give us any of those building, but she never gave us the salary of Jason Momoa or the other comparable. She showed us with her words, the beautiful clothing.
All right, I'll sustain the objection. Next question.
Okay. You were just speaking about Mr. Momoa as a comparable. Are you aware that Ms. Arnold compares Ms. Heard to equivalent franchise experience, who was able to renegotiate his salary for
franchise experience to
who was able to renegotiate his salary for significant increases in bonus.
Experience to Ms. Heard. He was Conan the Barbarian. He played Aquaman not a supporting character like Mira. It's just nothing from Miss Arnold to back it up, something to build on, which if she was a negotiator in the trench, the studio negotiates, where's the comps? Let's talk.
In your experience in the industry, what factors influence the negotiation of the terms?
I mean, first, it depends on the film. If the film is $1 million movie, and for deal makers and negotiators, the best predictor of what the precedent comps, he has another price for that movie, but the best predictor of future earnings is past earnings. And I didn't see, the network has no more options. Until then, if it's a success, and the studio wants to continue making the series, and they want to keep these characters.
Timing of the Waldman statements to the opportunities Ms.
Says that Ms. Heard lost all these opportunities. So I think the timing.
Sure.
Opinions in this case.
She may have gotten someone at the building blocks.
Objection.
My opinion, as someone who's she doesn't have the background, she doesn't have the day-to-day knowledge. Want to get those figures, you have to show why they're deserved. And again, pieces. It does not hold up under scrutiny by someone who makes deals.
So you agree that studios, you have an issue with the comps that
She didn't disclose.
the comps being the actors that you just talked about. She did disclose, I mean, she disclosed the actors.
She disclosed the actors and disclosed their salaries and salary history as comps.
Question, are you offering a different set of comparators than what Ms.
Comparators.
That was my question. You're not offering comparators, correct?
No,
After that, just answer the questions, Mr. Marks. Thank you.
Now, your deal,
I've negotiated a deal for Michael Douglas, not in a superhero movie, but a historical movie. I've negotiated recently on an Apple series.
movie.
As I sit here now, I negotiated over my career franchise movies.
For any actors for superhero movies, correct?
So you would define like, I don't know, Jungle Book isn't a superhero movie. It's more of a
Your answer
okay,
is no.
all right. So as I sit here, I can't think of a Marvel type Marvel type superhero or two in there.
Now, you testified and you agree that Mr. Momoa negotiated his multi-picture contract for Aquaman 2, correct?
To say there was a renegotiation, options were out. What he was earning, if you tell me that, I haven't seen his contract and I haven't heard any test options for when they made that leap. Did they get more options?
If there's an Aquaman 3, if they engaged her, she would receive $4 million, correct?
$4 million.
Would you agree?
For future studio superhero movies and alone, that could be other type of studio movies. Assuming everything was equal.
You agree
That she makes, but she is not Aquaman. She is Mira.
But it was a breakthrough movie for Ms. Heard, correct?
Not Aquaman. She is Mira.
But it was a breakthrough. And she was the female star of that, correct?
She didn't give us the raw materials to look at, but I'll take your word that all those unrelated Jason Momoa, they went up. As did Miss Arnold's when she went from 1 to 2.
In your experience, can you identify performance in a superhero movie?
As I sit here now, I haven't been asked to opine on that, but they don't appear in the next movie.
But a female star in a breakthrough movie in a superhero movie.
Well, so she did. Miss Heard did not get any movie.
Not gotten another studio movie after their breakthrough in a superhero movie. You're not providing an alternative number for Ms. Heard's damages, correct? For the jury.
Correct. Adequately paid.
I'd move to strike after no, I've not been provided another number. That's all. I mean,
Mr. Marks, in response to some Mr. Marks, in response to some questions from Mr. Lederhaft, you were fantasy movie agreements that you've negotiated with actors. Could you just describe some of those for us? The movie agreements that you've negotiated with actors. Could you just describe some of those for us?
I've had such a long, but I negotiated all the contracts for Pinocchio, if you will, that was produced. Is Coming to America, the original, is that a fantasy movie? The Golden Child, is that a fantasy movie? I may have negotiated contracts, and ultimately the film wasn't made. But as I sit here now, my resume or going through my files, I might think of others. But
Nadel has questions that you have negotiated some deals for heroes.
I believe they.
Thank you, Mr. Marks. You can, you're free to stay in the courtroom or you can leave, okay?
Thank you very much.
Thank you. All right, your next witness.
Didn't learn.
Michael Spindler. You've testified previously, correct, Mr. Spindler? All right. Just a reminder that you're still. Yes. All right. Thank you.
Morning. Can you remind the jury who you are and what you do?
I'm with B. Riley Advisory Services, a national firm. I've got over 40 years of experience.
Are you familiar with the testimony rendered by Ms. Arnold and suffered economic damages resulting from 3 statements made by Mr. Waldman?
Yes, I do.
Do you have an opinion of that claim?
Objection, Your Honor. May we approach?
All right.
Thanks, Mr. Spindler. Now, you of Ms. Hurd relative to by Ms. Arnold.
Yes, I have.
And what's that opinion?
It is not
Analysis. Both damages. What is your opinion of the claims that have been asserted?
To her damages calculation. There was no comparable actors and seemed to use that as a basis for numbers. She didn't provide the underlying calculation. She didn't provide underlying support. In her testimony, she backed away a little bit from that, but she still suffers from the issues of not providing detailed calculations or support for where those extent appears to be using some kind of comparable analysis. That something that is anchored in facts, taking a look at historical compensation as a basis for anticipating.
And you looked at Ms. Hurd's prior compensation?
Yes, I have. I've looked at tax returns that were provided for the period of 2013 through 2019.
Why do you want to use historical earnings?
Well, once again, you want an analysis is anchored in. So here we've got some actual data. We've got some historical compensation. In addition, I believe that Ms. Arnold herself said that she had hoped to be able to, as a basis for future compensation, that being the new kind of.
In your analysis.
2019 in total, her compensation was around $10 million for all those years combined. $2.6 million and $3 million. Now that's a good year, and was released in December of 2018, and that was a success. Also don't have any potential impact.
What did you understand Ms. Arnold's methodology to be?
That she had identified. And theoretically, the compensation that they earned, although she doesn't identify what that compensation.
What is your opinion of that methodology from an accounting perspective?
That methodology was unsound that she provided and support for that.
What methodology did you understand Ms.
Okay, well, it looked like somewhat of a mix and match approach. She used different approaches, I believe, for different elements of the damage. Clear to me, a little bit vague, but there are 4 basic components that she was looking at. And we can.
With respect to the television series portion of her analysis, what do you want?
Objection, Your Honor. May we approach?
All right.
earnings from television shows. Did you analyze concerned with relative to television shows?
Well, yes. During 2019, she entered into a contract in July of 2019 to appear at $200,000 per episode.
All right. What about period?
She did have a contract with L'Oreal. And
movie roles. What were
the Warner Brothers deal, which was a 4-picture deal. The first film was $450,000 fee, base fee. Then $2 million for.
Why do you look at historical earnings as part of your analysis? Look at the analysis that you're doing. What you said, I think, is you wanted them anchored in facts. Why?
Basis for coming up with something with reasonable certainty. There's AICPA, or American Institute of Certified Public Accountant guidance with respect to reasonable certainty.
Thank you. No further questions.
All right, cross-examination.
Hello again, Mr. Spindler.
Good morning.
I'm going to ask a counterclaim against Mr. Depp. When I refer to those statements, I'm going to refer to them as the Depp-Waldman statement.
That's fine. You can use your terminology.
I'm sorry, there's an objection, sir. Hold on.
Can we approach it?
Waldman statements, you understand me to be referring to the statements in Ms. Heard's counterclaim against Mr. Opinion to Ms. Arnold's, part of Ms. Arnold's testimony, correct?
Correct.
You're not offering an opinion as to what any of the underlying facts relating to that you believe Ms. Heard may be entitled to if she proves defamation by Mr. Depp. You're just reviewing what Ms. Arnold has said, correct?
That's correct. And
you said that you want your analysis in the facts, right?
Anchored in facts.
Anchored in facts. You'd agree that what an actor earned.
Correct. Correct.
And that's because
there can be some variability. Yes.
An increase in the number of roles may lead to greater income, correct?
I'm sorry. Could you repeat that? I was speaking. I didn't hear.
May not be reflective of what an actress may earn in future periods is because an increase in the number of roles may lead to greater income.
The project itself, yes.
Sure. Getting better roles may lead to greater income, correct?
Correct.
And the same is true for an endorsement. As an actress's profile, correct?
It can.
So
it depends.
What Ms. Heard earned from, say, 2013 to 2019?
Not necessarily.
So
it depends.
What Ms. Heard earned from?
Not necessarily. It is a good indicator. There was a slight increase during that period of time in her earnings from 2013 through 20.
Now, you're not a causation expert, right? You're just a damages expert. Offering any opinion as to whether the Depp-Waldman statements kept her from...
I'm not testifying on causation issues.
And you can't speak to what opportunity...
I've not done those calculations.
And you don't have an opinion about whether or not Ms. Heard could have renegotiated a contract for Aquaman 2, correct?
That was not part of...
Exposure or press coverage or magazine covers or interviews would have had on Ms. Heard's career, correct?
Correct. I'm just looking at Ms. Arnold's calculations.
You've never witnessed before to calculate damages based on lost roles.
Calculations as an
expert witness in a case to calculate damages based on alleged defamation against an actress, correct?
Correct.
And you're not offering any expert opinion alleged defamation by Mr. Depp has had on Ms. Heard. Alleged defamation by Mr. Depp has had on Ms. Heard's career, correct?
I'm sorry, one more time?
You're not offering any expert opinion on what impact by Mr. Depp has had on Ms. Heard's career, correct?
Other than taking a look at Ms. Arnold's calculations.
And you're not offering any expert opinion coverage of this case or of Ms. Heard may have had on Ms. Heard's career, correct?
You're correct. That's other experts.
Can we approach
No further questions. Thank you.
All right.
For you.
Okay.
All right. Witness? witness.
Plaintiff calls Doug Banya, Your Honor.
Okay. Can you spell the last name for me? So just a reminder that you're still under oath, okay, sir?
Can you briefly reintroduce yourself to the jury, please?
Yes, hi, Doug Banya. I am from Nevium Intellectual Property Consultants based in San Diego. Property, I provide litigation support in infringement and defamation cases, as I'm doing today, and I use internet and social media in both of those services.
Since you last testified in this case, the jury has heard testimony from Ronald Schnell and Catherine Arnold. Are you familiar with their testimony? Were you asked to analyze their testimony and provide opinions in response?
Yes, I was.
Have you formed opinions in response to the testimony of Mr. Schnell and Ms. Arnold?
I have.
Generally, what are?
Generally, Mr. Schnell provided no evidence of a correlation between the Waldman state, the hashtags, and the spikes of those hashtags on Twitter. Second, based on my internet and social media analytics, I've concluded that the alleged comparable actors that Mr. Schnell and Ms. Arnold of a causation, as it Waldman statements, causing any economic.
2.7 million alleged negative tweets related to Ms. Heard between January 2018 and June 2021?
Yes.
And what's your understanding of how Mr. Schnell 8.7 million tweets?
Yeah, so essentially Mr. Schnell chose hashtags that he felt were negative towards Ms. Heard. Those range from justice for Johnny Depp, Amber Heard is an abuser, Amber Turd, and the hashtag, we just don't like you, Amber. Hashtags, and he searched through, using the Twitter API, searched through various tweets, and then came up with any tweets that were.
Did you conduct an analysis of those tweets?
Yes, I was given that exact, the data that Mr. Schnell used on a hard drive. So yes, I.
And what was the purpose of your analysis?
So what I'm trying to do, and what's at issue of the case today at this point is, were these tweets, did they contain the Waldman statements? Where we're at right now are the Waldman statements. So I wanted to analyze those tweets to determine which ones, and if any, contain the Waldman statements.
And what's your understanding of what the...
So my understanding is there's three Waldman statements that were published, and Mr. Arnold was quoted in three of those articles, and those dates were on April 8th, 2020, April 27th, 2020, and on June 24th, 2020. And my understanding that those quotes, sorry, I think I said the wrong name, but those quotes are the only remaining in this case.
Talking about as compared to the timing of the Waldman statements?
And that's exactly what I did. So I wanted to look at the Waldman statements, look at the dates, and that's exactly what I did. So I wanted to look at the Waldman statement.
Have you prepared a demonstrative that reflects that aspect of your analysis?
Yes.
Your Honor, may I approach?
Yes. Did you show counsel? So 1293 will just be marked for identification as demonstrative and can be published to the jury.
Mr. Vanya, can you explain to the jury what this demonstrative shows?
Yes. Hashtags and tweets that Mr. Schnell was analyzing. This is the summary data to June of 2021. And again, these are related to the four hashtags that I discussed. Whenever I get an assignment such as a defamatory statement that's allegedly gone viral online, where there's economic damages involved and there's a lot of data involved, I like to take the data and I like to do a 10-foot view of the data to see what I'm looking at, to see if there's anything interesting, odd, different about the data. And the first thing that I noticed is 35% tweets were prior to the Waldman statements. So again, remember, my assignment is to determine if the Waldman statements are part of the tweets that Mr. Schnell analyzed. So obviously, these tweets were prior to the Waldman statements. In no way could they have anything to do with the Waldman statements. So that was the first issue that I noticed. What I like to call kind of the alleged defamatory time frame. And as I discussed, that's when the Waldman statement, that's the date down here. You know, the first one was in the beginning of April, and the last one, which is the third one, was at the end of June. But what I found interesting is only 2% of the tweets happened during this Waldman statement period. So really, these are just observations. And for me, there were red flags that I made note of, and then I analysis.
What other work have you performed in connection with forming your opinions about the purport?
During this important period, I just continued to dig into the 2.79 million tweets that Mr. Schnell provided.
And Mr. Banya, have you prepared another demonstrative that depicts that analysis that you were just describing?
Yes.
Okay, we'll just see if he has an objection. No, I'll give you time to look at it, sir. All right, plaintiffs, if you turn on your microphone, I'm sorry.
No.
Okay. All right, plaintiff's exhibit 1294 will be marked for identification as a demonstrative and will be published to the jury.
Thank you, Your Honor. What this demonstrative shows?
Yes, this is showing the various spikes as it relates to the hashtags that Mr. Scheid about. This is actually an exhibit or a demonstrative that he used in his testimony. What this is showing are the largest spikes related to the justice for Johnny Depp. I don't know if you remember his testimony or any of his demonstratives. The other three hashtags did spike at the same time, but a very small spike are the 6 top spikes in Mr. Schnell's analysis. And what's important here again is the very first largest spike, again, happened before the Waldman statements. So what I'm trying to figure out is what tweets were related to the Waldman statements. So this number one, the biggest spike, was prior to the Waldman statements, so it's irrelevant to the case. And then the second thing I noticed that was interesting here is here are the dates in gray, right here. This is the time in which the Waldman statements happened. And you're going to notice, as we discussed before, only 2% of the tweets happened during that time. But I found it very interesting for that has potentially caused such economic harm. There's no spikes in this area. And actually, you're going to see that Mr. Waldman's statement came out here in the first April 2020 article. Then the second one came out here. And then the third one came out in June. There's actually a downward use of the hashtags So I'm not seeing any correlation as it relates to the Waldman statements and any spikes here as it relates to the hashtags Mr. Schnell chose.
Did you analyze each of the spikes that are depicted here?
Yeah, so what I did is it's different spikes, and you're going to notice that each spike represents a month. So the second spike, is July of 2020 and April 2021. And what I did is, I don't know if you remember in my last testimony when I went into Google search, and I'm able to go into Google search, I went in and I typed, and then after you hit search, what was the general public being fed as it relates to Amber Heard back during the research results, because they represent 50 to 70%.
Only that the tweets using the 4 hashtags he looked at were mathematically correlated.
For hashtags that he randomly chose, they tend to go up and down together, and that's why he had these spikes here. So they work or dance together going up and down, but first of all, the hashtags have nothing to do with the Waldman statements, and the fact that there's a correlation with the hashtags is because we're dealing with the Waldman statements, which none of that correlation analysis he did had to do with.
Statements.
Can I clear this about all here? If when time you might see second time a big spike, and the third time a big spike, that's not here. So that's telling me there's no actually provided evidence that there's no correlation, because I analyzed each of these spikes and none of them had to do with the Waldman statements.
Is mathematics?
No.
Why not?
I mean, correlation is simply a relationship between 2 or more variables. In this case, same time did you see a correlation with spikes in these hashtags. And again, can we clear that right here? It's actually a downward trend. There's no spikes, there's no correlation. So, again, Mr. Schnell provided no evidence of any correlation. Correlating or moving together is irrelevant to the case, because the case is about the Waldman statements.
So what is causation then?
So cause a change in the other. So as it relates to this case, did the Waldman statements cause Ms. Heard not to make as much money in her career? And again, Mr. Schnell provided no evidence of this. Ms. Arnold's testimony yesterday, she didn't even know what causation was. She was asked, do you know the difference between causation and correlation? We're not talking about the words. When it comes to damages, you have to prove causation prior to calculating damages. So there is no causation. Therefore, a damages analysis is not appropriate.
Did you hear Mr. Schnell testify that he agreed with your opinion in this case?
Well, he agreed that he failed to link. He tried to do that. But again, his analysis say that 25% of the tweet that is, but it's not relevant to this case.
Mr. Schnell's testimony.
Again, the assignment was to determine if the Waldman statement's step is, now that I've excluded, the 35% that was before the Waldman, if any of those tweets, contained the Waldman statements.
All right, we'll mark it for identification as plaintiffs 1295 as demonstrative and published to the jury.
Consider the content of the statements made by Waldman as part of the work that you did?
I wanted to determine what, if any, tweets included terms and key themes for those Waldman statements, which are listed here. The Waldman statements, fake sexual violence. So what I did is we're now dealing with a 1.2 million tweets, because we're starting in April 2020, because that's when the Waldmans started. And what I did is I searched 751 tweets that included those key terms, which is 0.06% of the 1.2 million. And lifting and sorting and analyzing this data, I realized that a lot of the language to see if it matches one of these three. I realized that a lot of these tweets were any of those, and it came down with 95 unique tweets in there, and I identified 5 tweets. No, they don't, and because I am rebutting Miss Arnold, her testimony, she walked that back and admitted, no, none of these tweets have anything to do with the Waldman statements. They don't include the Waldman statements. These, and in his opinion, felt that they were negative towards Miss Heard.
Based on your expertise, what are your overall opinions about Mr. Schnell's testimony?
Mr. Schnell provided no evidence. There's no correlation there. He also provided no evidence that there's any causation that, harm towards Ms. Heard.
Your Honor, I'm about to switch to a different topic. I don't know if you want to break now or push.
All right, it's going to be a little while. Okay, do not discuss the case and do not do any outside research, okay? All right, we'll come back at 1:40 then. Is that right? All right,
Thank you, Your Honor.
All right.
Thank you, sir. All right, are we ready for the jury? Oh. We ready? Okay. Which of the jury? You may be seated. All right. Do you need to approach for a moment? Okay.
Mr. Banya, before lunch, we were talking about your opinions in response to the testimony of Mr. Schnell. Of her opinion that Ms. Heard's career would have followed the same trajectory as that of Jason Momoa, Gal Gadot, Zendaya, Ana de Armas, and Chris Pine, if not for the Waldman statements?
Yes.
Understanding of Ms. Arnold's basis for her opinion that Ms. Heard's career should have been similar to that of those identified actors.
Ms. Arnold stated that producers or her industry is looking to hire talent of the actors that they're considering, and that it's important to look into social media to see what is happening for either a movie or even an endorsement opportunity with companies.
Of those purportedly comparable actors?
No. Although she stated that, she went in without really the reasoning behind that.
Did you conduct an analysis based on your expertise in social media and internet analytics of Ms. Heard compared to the Arnold comparison?
I did.
And what did you find?
Well, since Ms. Arnold stated that the proper approach is looking at the public perspective, looking into social media, she did not do that. I felt that was the best approach to do this based on her words. So yes, I did go into best understanding the public perspective of Heard and the alleged comparable actors using Q scores. Then I also went and did some analysis online and on social media as well.
Can you briefly remind the jury?
In Q scores, measure how well a celebrity, it's an industry standard tool that's used. It's not just focused on the movies that they're in, but what's happening in their personal lives come to play as well. So that's how Q scores are typically used.
Did you prepare a demonstrative that reflects the Q score analysis you completed? May I approach again?
All right, thank you.
No objection.
For identification and published to the jury.
Mr. Banya, what point in time do these Q scores?
The winter 2009.
What point in time do these Q scores represent that are reflected on your demonstrative?
So this the winter 2019 Q scores represented Miss Heard after Aquaman, and remember Aquaman is December of 2000, but before the Waldman statements.
And what did you find based on the Q scores that you looked at?
As you can see, Miss Godot has the highest Q score out of Miss Heard has the lowest positive Q score. She has a 9. So I find that very interesting that she doesn't appear to be comparable with these alleged comparable actors. I think what's also interesting is the average Q score for all actors being scored at that time, which include alleged comparable actors here, score at an average of 17. And you can see, again, she is 9, well below that. And then on the right side, so this is how much people dislike you. So the lower the score is better. You can see Mr. Momoa is over here with the lowest at an 8, but you can see 28, which was quite a difference. A 20-point difference from Mr. Momoa, and also a 10-point difference, from the average of all actors. So very, very much little. Her positive score is very low, and her negative score is very high, which is alleged comparable actors.
What opinions did you form based on that Q score analysis?
My opinions as it relates to these Q scores is Miss Arnold used these actors as allegedly comparable actors, but really listening to her testimony yesterday, it appears approach. I don't think she's using these comparable actors or these alleged comparable actors anymore. She's more relying on her.
Criticism of your use of the Q scores here?
She did, yes.
And what's your understanding what that criticism is?
Well, what actors after each of their break.
Use of the Q scores here?
She did, yes.
And what's your understanding what that criticism is?
Well, what I believe actors after each of their breakout films, which I disagree. First of all, Q scores doesn't work. Scores are available twice a year, so it's not that I could pick a month or a different month for each of the Q score actors. So what was important for me, and this doesn't always happen when I'm using Q scores, you can get this perfect moment in Miss Heard's breakout moment. So these scores reflect that breakout moment, and they're terrible Q scores.
How would your Ms. Arnold's logic with respect to the timing of the Q scores that you looked at?
I mean, if you really think about what Miss Arnold was saying, is she's saying that are the highest for each actor right after their breakout moment. So I would think, if anything, these Q scores could have been a bit lower because it's not a breakout moment. But what's important for me is the fact that these scores reflect, who Amber Heard was at the time before the Waldman statements, but after the Aquaman release.
We can take that one down, Tom. Thank you. What other work have you done in connection with forming your opinions in this case?
Again, taking the advice from Ms. Arnold, it's important. Says the industry looks into social media, what their followings are like, with the numbers as it relates to their followers. Again, what is the public perception of them? Just their social media accounts, but prior to the Waldman statement. So.
And how did you do that?
Yeah, so what I did, the archive.org, they have a tool called the Wayback Machine. What archive.org does is it archives the internet. So you can go back in time to see what web pages used to look like in the past. Not all the time can you actually get celebrities' social media accounts to have been archived, but the alleged comparable actors' social media accounts were in archive.org. So I was able to go back in time prior to the Waldman statements to see what the following activity each of the alleged comparable.
Prepare a demonstrative that reflects your social media analysis?
Yes. Factors.
Mr. Banya, did you prepare a demonstrative that reflects your social media analysis?
Yes.
No objection to the demonstrative.
All right, we'll mark it for identification purposes, plaintiffs 1297 and publish.
Mr. Banya, could you tell the jury what social media?
Yeah, so what I found, again, this is prior to the Waldman statements. First thing you're going to notice here is not all actors use social media. You're going to see Mr. Pine doesn't have Facebook, Twitter, or Instagram, and Momoa and Darmus don't use Facebook or Twitter. But what's important to look at is you have Ms. Heard prior to the 0.8 Instagram followers and 142,500 Twitter followers. And then you move down to Gal Gadot with 37 million Instagram followers compared to her 3.8 million, and 2.3 million Twitter followers compared to Ms. Heard's 100. And you can then even go down to Zendaya with 65.9 and 17.2 million Twitter followers. What this is telling me is really are interested in Ms. Gadot and Zendaya and even Mr. Momoa than Ms. Heard on social media. It just tells me a lot. Actors as opposed to Ms. Heard, more of a following. Q scores, well-liked, less disliked. So it kind of fits into the analysis of determining whether or not these allegers are actually comparable.
Based on your expertise, what are your overall opinions about Ms. Arnold's analysis of the so-called comparable actors?
Yes, again, it appears that, and I agree with that. I feel that, through the Q-score analysis and the social media analysis, that they're just not comparable.
Mr. Banya, based on all the analysis you did in this case, what are your overall opinions?
Yes, my overall opinions are that Mr. Schnell, any causal connection with the Waldman statement there. My second opinion is, based on my social media and Q-score analysis, Ms. Arnold and Mr. Schnell both failed to prove any causation as it relates to the Waldman statements causing to Ms. Heard. So, as a damages expert, which Ms. Arnold is, you need to take into consideration causation before you can calculate damages. It's the allegedly damaging event. And not only do you have to prove that 100% of the damages because of these Waldman statements, she didn't even consider COVID at the time. A lot of actors probably made a lot less money because of COVID. Maybe films didn't get made. And, when you do an analysis of damages, you prove causation, but you also that might have caused this alleged economic harm. And she didn't look into any of that. She didn't even know what causation was. So I don't think damages is an appropriate approach.
No further questions, Your Honor.
All right, cross-examination.
Good afternoon, Mr. Banya.
Hi.
You're not a damages expert, correct?
I am a damages expert, but not providing any quantitative damages opinions.
Okay. And is it your testimony that only if a person repeats the Waldman Depp statements could they be related to the defamation?
Time?
Are you saying that a person literally has to repeat the Waldman Depp statements in a tweet for them to be related to the defamation?
No, if you looked at my 3 themes as it relates to the tweets, and I analyzed those themes, and I came up with 5 examples of when those themes were used.
And you ran searches for, quote, abuse hoax, sexual violence hoax, and fake sexual violence, and you ran all those in quotes, correct?
I did.
So only if a person used a tweet with those words, with that spacing, would they hit on your searches, correct?
Objection, compound.
Overruled.
Yeah, so I used them in quotes because, hoax could be used in many other, to make sure I was fitting my search with the theme of the Waldman statements.
So if someone tweeted Miss Heard faked sexual violence, that wouldn't appear in your searches, correct? An ED.
It would not.
Okay. And if they use 2 spaces between abuse and hoax, that wouldn't fit in your search. Did you? And a tweet can only be 280 characters, correct?
That's correct.
All right. So certain of the Waldman Depp, a person could not tweet the whole thing in one tweet, correct? The whole statement in one tweet.
The Waldman statements?
Correct.
You could not tweet those entire quotes.
Did you make any determination if there was an online bullying campaign against Mr. Depp after Miss Heard's op-ed?
I didn't look at a bullying campaign for Miss Heard nor Mr. Depp.
Did you determine if there were tweets harassing Mr. Depp that quoted from Miss Heard's op-ed?
No, my assignment was to determine if the Waldman statements that Mr. Schnell provided. I was rebutting him.
And in your analysis of when you testified before, you never looked to see if.
All right, questions withdrawn. Next question.
Now, to Ms. Arnold's use of comparables, correct? Just the use of comparables in general.
I listened to her testimony and my understanding that she abandoned that approach, but as it relates to my testimony today, my opinion was related to those specific alleged comparable actors that they were.
You're not offering an opinion as to who the appropriate comparables should be to Ms. Heard, correct?
Correct.
You testified just before about the Q scores of Ms. Heard and the comparables. That was Plaintiff's Exhibit 1296, correct?
I don't know what 1296 means.
Okay. All for the winter of 2019?
I said Ms. Heard's were from the winter of 2019.
Because isn't it true that none of the rest of these people were from the winter of 2019, correct?
That's correct.
Okay. In fact, Mr. Momoa's was from the summer of 2020? Of 2020?
Comparable actors had Q scores for that date. What was important for me is get Ms. Heard's Q scores. Right after Aquaman, but before the Waldman. Say that same years.
Well, so in the winter of 2019 to February 7th, 2019, correct?
That is correct.
So that would be so the field work would be starting almost immediately after, correct?
Yeah, in her Star is Born moment, yes.
You'd agree that for the winter of 2020, where you took Jason Momoa's Q score, would have more time to account for the rise of Aquaman, correct?
Well, actually, if I use Ms. Arnold's suggestion, these celebrities tend to have, the celebrity moment right after they have their breakout film. I disagree with that. I think maybe his Q scores could be lower as it relates to when I use them.
You'd agree that for the winter of 2020, Mr. Momoa's Q score would have more time to account for the film Aquaman?
I don't know if it accounts for the rise of popularity. Again, using Ms. Arnold's words, usually a Q score will be the right after the film, like I did measure Ms. Heard.
All right. Do you show? Thank you. All right. Thank you.
If you look on page 177 of your deposition transcript, you see that?
I don't see a page. Is that what you handed me?
You don't see page 177? 4 pages? 4 pages per?
Oh, yes, thank you.
And I asked you at line, you'd agree that for the winter of 2020, Jason Momoa's Q score would have more time to account for the rise of popularity in the film Aquaman, and you answered yes.
At that time, to Ms. Arnold, based on her testimony, I've learned something new from her. Or to Ms. Arnold, based on her testimony, I've learned something new from her.
Okay. You didn't look at Ms. Heard's Q score for summer of 2020, correct? Armis.
She doesn't have any.
Armis had a lower familiarity score than Ms. Heard, correct?
If I don't have that in front of me, but if you're saying that, yes.
Okay. And Ms. Armis's trajectory has gone up since the summer of 2020, correct?
I don't know. I didn't analyze her career trajectory.
Put up plaintiff's trial exhibit 1297. That was the demonstrative. Ms. Armis has less Instagram followers than Ms. Heard, correct?
Correct.
And the Instagram followers of Ms. Armis, correct?
Yes.
Okay. And isn't it true that you get more social media followers the longer you're on social media?
Necessarily, it doesn't work that way. It depends on many other factors.
And so Ms. Armis had a lower familiarity score and less Instagram followers, yet your testimony is that proper comparable to Ms. Heard?
That's correct.
Okay. And you're not offering a different set of people who should be comparables, correct?
That's correct.
Okay, thank you. Now, you understand that Mr. Waldman has been banned from Twitter for life for harassing Amber Heard, correct?
I don't know that, but if that's the case.
Objection, Your Honor. May we approach on this one?
Okay, sure.
You agree that in looking at Mr. Schnell's data, some of the uses of negative hashtags relating to Ms. Heard occurred between April 1st, 2020 and June 15th, 2021, correct?
Correct.
Okay. And you would agree spikes of the negative hashtags were after the Depp Waldman statements, correct?
Correct.
Okay. And where you talked about the February 2020 spike, and the 65%, by the way, even includes the February 2020 spike of...
That's correct. Well, there was no spike in Feb 2020 during the Waldman statements.
Well...
I would have you. Can we pull up the chart again if you want to talk about the spikes?
Sure. Can you put up 1294? Number one.
That spike happened before the Waldman statements.
Okay. And there was hardly any activity in negative hashtags until February 2020, correct?
That's correct.
The spike in February 2020 was related to the partial tape that Mr. Waldman and Mr. Depp leaked to the Daily Mail, right?
I'm aware that the articles were related to hitting Depp.
And you understand that Mr. Waldman testified that Mr. Depp and Mr. Waldman met with the Daily Mail in person to provide the partial tape to the Daily Mail.
Objection, Your Honor.
He talked about what the number one related to.
What's the objection?
Sorry, lack of foundation and...
I'm asking if he knows or he doesn't.
All right, we'll rule.
So what's important to me is the fact that prior to the Waldman statements.
Do you know if Mr. Waldman testified that Mr. Depp and he met with the Daily Mail in person to provide the partial tape?
No.
In February of 2020. You don't know one?
Opinion.
Okay. And the spike in July of 2020 came right.
The July spike, which is number 2, is not related to it. That's correct.
Okay. And the July spike in time came after the June 27th, 2020 defamatory statement by Mr. Depp and Mr. Waldman, correct?
That's correct.
Okay. And 5 of the 6 spikes came after the defamatory statement. Testified before that you eliminated shares and likes of the Depp Waldman statements from your analysis, right? Shares and likes of tweets that included the Depp Waldman statements?
That's correct. When I was doing my analysis, I noticed the exact same text was those tweets.
Don't shares and likes disseminate the negative information?
Does
And you agree, right, that use of the term Waldman or Waldminian occurred from April 2020 through January 2021, correct?
Although it's irrelevant to this case, it has nothing to do with the Waldman statements. That's what Mr. Schnell says.
You don't disagree with his, you don't disagree, correct?
Although has nothing to do with this case or the Waldman statements, I do not disagree.
So if people are tweeting about Adam Waldman or Waldminian, is tweeting negative hashtags about Amber Heard, it's your testimony that they have nothing to do with this case?
The hashtags have nothing to do with this case.
Okay.
Yeah.
Okay. And even if they include the negative hashtags with Mr. Waldman's name and Waldminian, you're saying they have nothing to do with the defamatory statements?
All four hashtags used had nothing to do with the Waldman statements. Again, it has nothing to do with this case, and it's not related to the Waldman statements. That's what's important.
And the reason you're saying they're not related to the Waldman statements is because someone didn't literally copy what Adam Waldman said in the Daily Mail.
Well, I looked at enough tweets that included the name Waldman that have nothing to do.
The only way that those would have been in the data you looked at would have had the negative hashtags towards Ms. Heard. He wasn't looking. It was looking at that universe, correct?
Well, first of all, I don't agree that this for Johnny Depp is a negative hashtag towards Amber Heard. So, listen, the assignment was to determine if the tweets that Mr. Schnell presented.
The tweets related to Ms. Heard, you cannot point to any that were positive toward Ms. Heard, correct?
Again, I was not looking for that.
And you did not review the hashtag Justice for Johnny from April 1st, 2020 to January 1st, 2020 to see if there were any that were not negative toward Ms. Heard?
I did not look into anything as it relates to then what relates to the Waldman statements. That's what's at issue here today as we sit in court.
Okay. And you didn't form any statistical analysis to rule out the Waldman statements' impact. You did not analyze whether media and press coverage other than the Waldman statements affected Ms. Heard's career, correct?
Correct.
Okay. Looking at the exhibit that's in front of numbers here, those you said are related to Google searches?
The 1 through 6?
Correct.
Yes.
Okay. And can we put up plaintiff's 888? And we could just start at your, okay. Oh, thanks. And 888, it's page 76. These documents you relied upon for your opinion today?
Yes.
And are these the search, where it has a different letter, are the searches that you ran for the various time frames and the articles that came up for numbers 1 through 6, correct?
No. I mean, document 1A is the Heard supplemental expert witness disclosure. These are documents that I used throughout the time I've been working on this project. So these aren't 1 through 6 numbers.
Okay. These are documents you relied upon for your opinion today?
These are documents that I relied upon when I presented my
for your opinion today, that you're offering today?
Yeah, these are the documents that, yes, I've relied on throughout this case.
Okay. And could you turn in this designation to let's see. Hold on one second. Can you just scroll down? Yeah, keep scrolling. Just keep going. Okay, stop. This was the chart you provided with your designation for your opinions?
Yes.
Okay. And it's similar to the chart that we had before with the 1 through 6, correct?
That's correct.
Where it has the various boxes, it's talking about documents 6E through 6H, for instance, related to Depp wanting to have Heard replaced on Aquaman.
Yes.
And you prepared this chart, correct?
Yeah, this was part of my designation.
I'd like to have this page as a demonstrative.
Your Honor, I do have an
All
objection.
right, if you want to come forward, page 99.
Mr. Banya. Other than so as I understand it, the way you determined that the tweets were not related to the Waldman statements was that you looked at time and then you Google searches, correct?
Correct.
And then the top 3 hits came up.
Correct.
And then you looked through the article to see if the Waldman.
So as it relates to any trending event, any defamation that's happened online, any allegations of because something went viral, going to Google, looking at the spikes in time and going back in time to see what was happening on those top 3 sites will give you of the best results that were being served at that time. So something viral that's happening would appear most likely in those top 3 results.
And just so the record's clear, if we could go back to page 70. Numbers 6A through 6N, going to the next page. Those are the headlines of the searches that you found?
Correct.
Okay. And you don't disagree that that negative tweets toward Ms. Jude throughout the analysis of the tweets, correct?
I'm not looking at whether they're negative tweets or those hashtags are negative. I'm determining if those Waldman statements.
Right, okay, and you haven't, you have no opinion whether the tweets were positive or negative towards Ms. Heard. That's what you're saying?
Yes, I'm just analyzing whether or not they're related to the Waldman.
Thank you. Nothing further.
All right, redirect.
I have no further questions of this witness, Your Honor. Thank you, Mr. Vanya.
Yes.
Sir, you can leave the courtroom or you please stay.
Thank you.
All right, your next witness. Do not discuss the case and don't do any outside research. Sorry, do not discuss the case and don't do any outside research. Sorry, we'll just take a short break. All right, so just so that we're on the same page, you can have a seat. Keep standing the whole time. We're on the same page with Mr. Knight's testimony. Actually, could Mr. Knight go back out, please? All right, so we're on the same page with Mr. Knight's testimony. There is a rule on witnesses. However, Mr. Knight's a rebuttal witness, excluding witnesses from the courtroom. Usually it's a courtroom, is to deprive a later witness of the opportunity to shape testimony to correspond. Obviously, if it was a direct witness in the direct testimony, you had time to do a rule on witnesses, let them know about the rule on witnesses. With a rebuttal witness, it's a little different because I know they were going to be a witness. You didn't know they were going to be a witness. I understand that part. The problem is the courtroom in this particular case, voir dire, and I'll allow both sides to ask questions as well, of Mr. Knight to see what he has seen of the case. And I'm just going to use the fact that the case law in Virginia uses, which the factors to consider, because the court does have broad discretion to permit or prohibit a witness to testify in this particular. The impropriety was intentional, which we'll find out. The prejudice attached to it. Also, if the excluded witness learned about substantive aspects of the case from an earlier witness, and whether that knowledge had any effect on his or her testimony. So those are the three factors I'm going to look at in weighing this decision. Mr. Knight will testify only relates to Hicksville. Is that correct? Okay. All right, now we can have Mr. Knight. Come back. All right, sir. Mr. Knight, if you could come forward to be sworn.
Do you solemnly swear or affirm to testify truthfully in this case and a penalty of law?
You could just have a seat, please. Sir, what we're doing is I'm just going to ask you, then I'm going to have you step back outside after that, okay?
No problem.
All right, what's your full name, sir?
Morgan Higby Knight.
Okay. All right, and sir, before I can allow you to testify, I just want to ask you a few questions. Have you seen any of the trial that's been going on for the past 6 weeks?
Approximately 5 weeks ago, a friend of mine texted me that Hicksville was mentioned, and I watched a little clip where it was mentioned.
Which clip did you?
I believe it was somebody testifying about, I think it was the security guard testifying maybe about Hicksville, or I forget exactly who was testifying, but it was something where Hicksville was mentioned, and it was that.
All right, and what did you do after that? At some point, did you get in contact with attorneys?
So I didn't reach out to them. I didn't really care. The innkeepers that worked at Hicksville before reached out to them and said, we saw some stuff that wasn't true, and then they asked, is it okay if I give the attorneys your phone number? So the attorney...
Okay, and when did the attorneys reach out to you?
May 3rd.
May 3rd. And you talked to the attorneys at that time?
Yeah.
Okay.
Not Camille, but Geraldine.
Okay, and then parts of the trial?
No, she instructed me not to watch anything about it, regardless of if it was about Hicksville or not. So I've been keeping off the internet and turning off to be like it's on social media, so I just don't watch any of that.
Okay. All right. And questions, Ms. Bretter?
So, Mr. Knight acted by an attorney for Mr. Depp on May 3rd. And what?
I think it's pronounced Geraldine.
Okay, can you tell us the conversation you had with her at that time?
Yeah, she just asked me my recollection of the evening, and she said, okay, would you mind testifying? And I said, sure. And she said, okay, well then, we're not sure if we're gonna call you or not, but just in case, please don't watch anything having to do with the case. And I said, I will do.
Now, how is it that Geraldine was able to get hold of you? How did she know that you knew something?
So, like I said, two of my innkeeper to her team, I think through email, out to her team, I think through email, and one of them texted me and said, hey, do you mind if we give Geraldine your phone number?
Now, you also communicated on Twitter, did you not, about this case?
Yeah, 2 weeks prior to Geraldine reaching out to me, made a comment about something that happened by the fire pit, and I said, that's not my recollection. I didn't see, that's not what I saw.
So who was it something that happened at the fire pit?
So once I was told about, but I was just like, what are they saying about Hicksville? And so that was why I did a search, just to see, because it was weird and fascinating, because the night to me wasn't that remarkable in the context of all the different experiences I've had at the Trailer Palace.
So explain to me, please, what you mean by you did a trailer search.
You go to Twitter and you put in keywords and do a search, all the tweets regarding that subject come up, or anything with those keywords in it. So that is how I do.
Okay. And how many tweets did you find that mentioned Hicksville when you did that trailer search?
Probably like...
Recall those tweets saying about Hicksville.
The one that I replied to said that there was some incident by the fire pit, and Johnny was yelling at Amber, and I replied that like that.
So your best recollection on that one was that somebody said somebody was testifying that Johnny was yelling at Amber?
Yeah, and grabbed her or something along those lines.
Okay. Do you recall who said Johnny was yelling at Amber and grabbed her?
I have no idea. It was a stranger, so I didn't really pay attention to who.
That you responded to it. How did you respond to it?
I said, that's not what happened. I was there all night. Yeah, basically. I'm paraphrasing.
Did you say anything about what you thought happened?
I just said that didn't happen. I didn't say what. I believe I said maybe something along the lines of, from what I saw, Amber was the one acting jealous, not Johnny.
And you said this to one of the tweets?
Yes.
Do you recall whether that was the...
I don't recall. That's a ridiculous name, though.
Okay. So tell me about the other 5 tweets that you recall seeing when you ran your trailer search.
They were similar in nature, but I don't specifically remember the details of them. That was pretty much the only one I remembered, and that's the...
Do you remember anything about the other 5 and what was said?
No.
Okay. When you said that somebody told you about a security guard, what was your understanding of what the...
I got a text that somebody in the trial had said that they were talking about Trailer Palace, and so that's what led me to go on Twitter and do a search.
And did you have any communications with the 2 innkeepers about what you knew?
No, I hadn't talked to them in years, and still haven't regarding the case.
So how is it that the innkeepers then contacted you and said, do you mind if we give you to the attorneys?
Because they still have me in their phone, and Christy, who was the manager at the time, is the one that texted me and said, hey, do you mind if we pass this along? They just want to talk to you.
Do you mind if we pass what along?
Your phone number.
Right, but how is it that, what is the communication you had with the innkeepers that even led them to understand that you believed you had knowledge about the Hicksville incident?
There was no conversation. They knew because they were both, Jenna was the innkeeper and she was there along with me that night. Christy was the one who texted me and she had come in the following morning for her shift. And I slept over. I was,
So I'm trying to understand. So just based on the fact that 7 years ago, they happened to know that you were working that night.
And it's because I was there with them.
My math, well, it's 2022 right now, and that was what year? Oh, that was
2013.
You're right. Okay. So how is it that out of the years ago that you worked there that night and that you might have some knowledge?
I mean, to be honest, like we do get celebrities sometimes. It was, you know, it's not that unmemorable. It's not like it's any other night of the week. So I'm sure they remembered the specifics of that night.
Had Mr. Depp's attorneys ever before?
No.
Had you ever attempted to contact Mr. Depp's attorneys before?
No, I had no interest.
All right. Have you had any conversations with Mr. Depp described with Geraldine?
Since?
Yes.
Well, I met with Camille last night.
All right. And what was that conversation? Please describe.
You know, the story again that I had told Geraldine.
And let's hear what that story was.
You want me to go through?
Yes.
The whole story?
Your Honor, we would have.
There's no attorney work product.
No, I'll overrule that.
All right.
That's fine. That's okay. Go ahead. Go ahead, sir.
Yeah, sure. I described like them getting to the trailer palace, me showing them around, the interactions I had with Mr. Depp and Miss Heard, how the evening progressed throughout the night, the levels of drinking and drug use that I witnessed, what the state of the damaged trailer the next morning, and just, yeah, the details that I had only, spent total 45 minutes to an hour with Mr. Depp and Miss Heard throughout the course of the night. So it was my recollection of those events during that time.
And what did Ms. Vasquez say to you?
We object on the grounds that it's beyond the scope of the voir dire,
No,
which is
I
limited
think
to the
whatever
three
she
criteria.
said to him is
May I
very
please finish
critical.
stating my objection, Your Honor?
Go ahead. Yes, sir.
The objection is that it's beyond the sphere, Your Honor, enumerated the three criteria which are relevant here. And this is a rebuttal witness, so.
Your Honor, whatever Ms. Vasquez shared with him is important here because they knew by this time he was going to be a witness. So,
That was last night. So how does that fit into one of the three factors of deciding whether or not he's going to testify?
Well, one of those, Your Honor, may I approach so that the witness doesn't hear?
Okay, that's fine.
Mr. Knight, did
Yes.
Ms. Vasquez provide you with any information that anyone had testified to or said at any point?
No, she didn't talk about anything. Give me my experience and just getting a clear understanding of what my experience was. She didn't mention anything outside of the scope of what I saw and just asked me for the facts and told me,
Do you know what any of the witnesses said in this trial?
about, outside of what I described earlier with the texting that someone was talking about Trailer Palace, I do not.
Do you know whether any of the witnesses testified about any
Other than the tweet that I replied to, no.
All right, sir, if you could have a seat back outside the courtroom.
Sure.
Thank you.
Can I leave my water?
Yes, you can leave your water. All right. So, Mr. Knight to testify. If we could get Mr. Knight back in. And if I knew you were going to do a sidebar, I wouldn't have made him leave. I never know. You could just stay there while we get the jury, okay? All right, are we ready for the jury?
Yes,
okay.
Yes, Your Honor.
Thank you. We're going to swear him in again in front of the jury, okay? Be seated. All right, thank you, ladies and gentlemen. I apologize for the interruption. You're going to notice as we get closer to the end of the testimony, you're probably going to, I apologize for that, but there's just some matters we have to take up outside your presence, okay? All right, thank you. All right, your next witness. All right, Mr. Knight, if you could come forward to be sworn.
Do you solemnly swear or affirm to testify truthfully in this case under penalty of law? I do.
Sir, if you could have a seat.
Good afternoon, Mr. Knight.
Good afternoon, Camille.
Would you please state your full name for the record?
Morgan Higby Knight.
Mr. Knight, where are you from?
I live in Los Angeles, California.
What do you do for a living?
So I currently own and run Hicksville Pines Bud and Breakfast in Idlewild, California. And I created and ran a palace in Joshua Tree, California. Starting in 2009.
And how is Hicksville Pines Bud and Palace?
So Hicksville Pines Bud and Breakfast is up in the mountains of Idlewild, which is a beautiful snow town. Above miniature A-frames instead of trailers, which we have. It's obviously a very different climate than Joshua Tree, which is a desert area. Our trailers, vintage trailers from the 50s through the 70s. At Hicksville Trailer Palace. So there's also different kind of amenities. There's a pool in Joshua Tree up at Hicksville Pines.
The owner of the Trailer Palace.
Trailer Palace, Stephen Butcher, and on the...
When did you first become the owner of the Trailer Palace?
Trailer Palace, I started building it in 2009. It took her and on the trailers, and we got done and opened in 2010.
Did there come a time that you sold the Hicksville Trailer Palace?
Yeah, I did. In 2020, I had some health issues and it was too much to run both at the same time. So I chose Idlewild because it was newer and shinier.
For my sake, how long did you own the Trailer Palace?
So 10 years of us being open, 11 years total.
And what was the Hicksville Trailer Palace?
It started out as a artist in Los Angeles. I also put in a recording studio so musicians could record records there. I had lived in New Orleans for 5 years, and a recording studio there called Kingsway, where all the musicians would come and they'd live in this big mansion and record their records. And I just thought that was a really neat thing for artists to be able to get away, create whatever they were working on. Over the course of the build out of all the trailers, themed trailers, which I'm a huge fan, and so I wanted to do really detailed themed trailers. It became too expensive to just make a living off of an artist retreat, so I decided before I was done to make it a hotel as well.
And what were your job responsibilities, generally speaking, when you owned the Hicksville Trailer Palace?
So I would be nights, a couple nights a week. I would also drive out from Los Angeles twice a week and bring supplies that you can't get out in the Yucca Valley area and Joshua Tree, Smart and Finals, Costco's and stuff. So I would drive that stuff out. There's also no USPS, so sometimes I'd have to get things shipped to my house and drive them out. I would also just do constantly building and creating new stuff at Trailer Palace, whether it's new trailers or amenities. So as well, I'm a big fan of the fact that Disneyland is always making it better and better.
And when you were the live-in manager, does that mean that you spent at the Hicksville Trailer Palace?
Yeah, we have a house on site where the recording studio was, and there's a bedroom in there. So whoever is live-in manager those nights stays in the house and everything.
Have you ever met the plaintiff in this case, Mr. Depp?
I had met him really briefly at the Viper Room in the late 90s. The people that performed there, and was good friends with this girl Robin from the Pussycat Dolls and some other friends in this band, The Imposters. So I was there and I met him once.
Ever met her?
I had never met her before. They were guests at the hotel.
When was the first time that you met Mr. Depp and Ms. Heard together?
In late May 20, when they were guests, Mr. Depp's assistant Nathan had rented out the entire place so they could have a night there in privacy.
And what do you recall Ms. Heard's arrival to the Hicksville Trailer Palace?
Mr. Depp got lost, so his security guard who arrived early asked me if I could go because he had an old car that didn't really fare on the dirt roads out there, which are pretty horrible. So I went out and made sure that they got themselves safely.
Do you remember approximately at what time that was?
It was 3 to 4 in the afternoon.
What was Mr. Depp's demeanor when they first arrived?
At Trailer Palace, he was excited about the place, really complimentary, just had a lot of questions and seemed like he was in a really great mood.
And how about Ms. Heard's demeanor?
She was pretty quiet. She just kind of didn't say that much when I was giving them the tour of the grounds and the trailer.
And was anyone else with Mr. Depp arrived?
There was people that were arriving throughout the afternoon. So there was, I think, 10 to 12 people total. The security guard had gotten there earlier and just to check out the place. But yeah.
And did I understand your testimony previously that the entire was rented out by Mr. Depp and Ms. Heard?
Yeah, the whole place slept, I believe at the time, about 25 people, but there was only 10 to 12 in this party.
And who was part of that party besides?
I'm really horrible with names, but I remember one of them was...
What happened when Mr. Depp and Ms. Heard first came onto the property?
So I gave them a tour of, we give all their specific trailer and the grounds and show them around the, when someone rents the whole place, they get another trailer called the bar trailer, which is basically a hall and stuff. And some people in the group were just putting their beverages in that area.
And where were you when Mr. Depp and Ms. Heard, did there come a time when Mr. Depp and Ms. Heard went to the bar?
I didn't notice most of the time that my interactions with them, everything's kind of centrally located. So there's a fire pit, bar trailer, and picnic tables all right in the same area. So they were there the entire evening that I saw them.
And what did you observe of Mr. Depp and Ms. Heard as the evening progressed?
So Mr. Depp was super curious and really nice. He was also really interested in my innkeeper because she was a musician, so they would talk about music a lot. At one point, at the next door property, went home and grabbed her guitar, and they had sung a song or two around the campfire in the early evening. And where Mr. Depp, the innkeeper, her name is Jenna, and myself were talking about books and music, and Ms. Heard came over and she seemed a little annoyed that Mr. Depp wasn't spending time with her.
What about Ms. Heard's demeanor made you think that she was annoyed?
I think just generally she, it's hard. Like I don't know. It was just like a gut reaction. Like I can't describe it, but
How long were you with Mr. Depp and Ms. Heard that evening?
So throughout the course of the evening, I was probably mostly with Mr. Depp, but 45 minutes to an hour total. So it was the whole course until the end of the night. after the check-in.
Okay. And did you have an opportunity to observe Mr. Depp interact with other people, guests at the property that evening?
I saw him hanging out with his security guard at one point, and outside of the time that him and Jenna were singing around the campfire, he was a lot of the time, and Ms. Heard was over at the campfire with her friends and seemed to have a good time.
And if you haven't already, can you generally describe for the jury your observations of Ms. Heard that evening?
Yeah, she'd be having a really nice time with her friends around the campfire. And yeah, everyone was in a pretty good mood.
Did there come a time in the evening that you observed Mr. have a disagreement or an argument?
Yes. I was speaking with Mr. Depp, just one-on-one, talking about Hicksville, and came over, and she said that I want to talk to you, and seemed really upset about something. So I went, and because it was really, they went off on their own, and she started yelling at him, and I didn't want to hear it. It honestly was really triggering because I've been in an abusive relationship before.
Objections. Move to strike.
What's the objection?
You're up. May we approach?
Okay, sure.
Mr. Knight, will you please just explain for us what you observed when you saw Mr. Depp and having an argument?
Yes. So Ms. Heard asked him to go talk off to the side, and she was upset at him. And I personally had been in...
Objection.
All right, I'll sustain the objection.
Okay.
If you could just, what you observed when you saw Mr. Depp and Ms. Heard having an argument.
Okay. He was kind of cowering and seemed almost afraid, and like odd to see because he was older than her, obviously. So, but I just went back in the house because I didn't
Objection.
want to.
All right, I'll sustain as to.
Understood. So after you observed the argument, fair to say you went back to to your house on site?
Yes, I did. Yeah.
Okay.
So when I saw Mr. Depp on my next rounds, he apologized profusely and said, "I'm really sorry about that." She was upset.
Object. Sustain. Next question.
What, if any, type of reaction did Mr. Depp have?
He was just really...
Objection, Your Honor. Hearsay. He's going to say it again.
It's the react statement.
All right, if you could make that clear, that's fine.
Just what type of physical reaction did Mr. Depp have after the argument between Mr. Depp and Ms. Heard?
He honestly, the night became a lot more quiet and was just very more petulant. In the beginning of the night, he was a lot more outgoing, and actually, as the course of the night went on, he was less and less so and more quiet.
Did you observe any of the guests consuming alcohol while on the property?
People had cups, and there was alcohol set up in the bar trailer, but I didn't physically see them pour alcohol into their cup and cup go into the mouth, per se.
Does Mr. Depp drink any alcohol that evening?
I couldn't say.
Anything about Mr. Depp's demeanor that made you think he was perhaps intoxicated?
Yes, I am a former bar owner, so even though I wasn't drinking that night, I'm very familiar with the signs. So as the night went on, like I said, he became more and more quiet, but he also, as we would have conversations, his head would kind of sway a little bit back and forth, which was a little, was than he was earlier in the night.
Did Ms. Heard appear intoxicated to you?
She did. She seemed, I think when she was angry at him, it seemed like she was intoxicated, but that's just based on my experience and my own personal trauma dealing with abuse.
Objection, Your Honor, move to strike.
All right, I'll sustain the objection. Please disregard that testimony.
Did you observe anyone do or
Strike it from the record. Please disregard that testimony.
did you observe anyone do or take drugs?
I did not.
Did you witness Mr. Depp and Ms. Heard interact other than the argument that you previously described for the jury?
At the end of the night, I heard a commotion. I was inside the house. What was going on? And Mr. Depp and Ms. Heard were having a discussion about I'm not sure what, but then they went. A lot of people had already gone to bed, so it just kind of petered out. Everyone went to bed, including myself, and I didn't hear anything else the rest of the night.
What time did the evening come to an end?
Almost around 3 a.m.
Did you ever see Mr. Depp grab anyone?
Objection, leading.
Sustained.
Did you ever see Mr. Depp become physical with anyone?
Sustained. Next question.
Did you ever witness Mr. Depp get angry that evening?
Objection, leading.
Sustained.
What, if anything, happened the next morning?
The next morning, we have checkout at noon at the time, before COVID. And so around 11 o'clock, one of my innkeepers let me know that there was some damage.
Objection, hearsay.
Did something happen that to Mr. Depp and Ms. Heard's trailer?
Yes, I was informed that.
Objection, hearsay.
It's not being offered for the truth, Your Honor. I mean, may we approach on this
Okay,
topic?
sure.
Thank you.
The innkeepers let me know that there was some damage in one of the trailers, and it happened to be Mr. Depp and Ms. Heard's trailer. So I wanted the trailer because I was extremely worried. All those trailers that Steve and I worked on were like my babies, and the one they were the only one that was mostly original and restored 1950s style, and so I was very concerned.
So what did you observe when you went?
I observed that there was a light sconce by the bathroom in the bedroom that had been broken off the wall, and a couple pieces were on the floor, and it was basically just broken. The light fixture was hanging on the wall still, except for the pieces that were on the floor.
Did you come to understand how that happened?
Objection.
Foundation. I'll sustain as to foundation. How you knew?
Did you ask how the sconce was broken?
Objection, hearsay.
Sustained.
Fixtures in the trailers break.
They break pretty often, vintage trailers, and I would say as much as every couple weeks there's some incident of damage in one of the trailers. In this case, Mr. Depp had told me that.
Objection, hearsay.
Objection.
So anyway, yes.
Beyond the light fixture, was anything else in the trailer damaged?
No, everything else looked fine. In fact, we have something we call a piggy fee address to guests, that if there's anything what we call inconsiderate or unusually large messes, we charge them extra for it for a $25 an hour cleaning fee. One of those, because everything outside of the light fixture looked fine.
And what was your reaction to seeing the damaged light fixture?
To be honest, I was relieved because it was not a big light in the room. So I just tucked the wires in the wall until I had a few months later time to buy. It was matching sconce with another one in the room. I had to, on eBay, find a matching pair that would fit there. And when I finally got around to it, I was able to get that and charge it to Nathan, whose credit card came out to $62.
did you ever wear a mesh shirt?
No, I would absolutely
Wear a mesh shirt?
No, I would absolutely never wear that.
At any time during see Mr. Depp become physical with anyone?
Objection leading.
Overruled. That's
I'm sorry, that answer was
I never saw Mr. Depp get physical.
Thank you, Your Honor. Mr.
I am not. To be honest, throughout the evening,
Sorry, I just asked you one question.
Oh, I
didn't
apologize.
ask you the rest of that.
I
You
apologize.
wanted to participate, didn't you?
I did not. I
You
was
knew-
asked by the attorney, and I wanted to. They asked me, and I said I'll be happy to come and tell the truth.
You knew this being broadcast to a lot of people, and you saw testimony, did you not, in this case? And you seized the moment and responded to the umbrella guy, person for Mr. Depp's Twitters. Did you not?
objection, Your Honor. Argumentative compound.
Overruled.
Mr. Umbrella Guy is the lead.
You
what?
know that he leads one of the most predominant pro-Depp Twitters out there.
I have no idea.
In fact, you do follow a Twitter called Johnny Depp fan, don't you?
Absolutely not.
You don't? That's your testimony under oath?
It is my testimony under oath.
All right. 21st, Mr. Depp testified in this case about Hicksville, didn't he?
I wasn't here.
And in fact, you tweeted to the umbrella guy on April 21, 22, quote, "That never happened. I was with them all night. Amber was the one acting." Do you
Yes,
recall writing that?
I do recall writing that.
Michelle, can
Well,
you bring that up, please? We're going to call it Defendants 1903.
1903.
And I'm going to go ahead and ask you to redact and the date and the bringing in the Hicksville. Your Honor, I'm sorry. I'm just... While she's working on that, consequence back in 1999.
I did.
And while we're looking at that, 4 days after you tweeted to Umbrella Man,
Umbrella Guy.
the Umbrella Guy, okay. Well, all right, now we have this up. I'm going to ask you to take a look what is Defendant's Exhibit 19.
I do.
Okay, and that's from that Umbrella Guy on 4/21/22, correct?
Correct.
And it says bringing in the Hicksville incident, accurate?
I do.
And there's clearly Mr. Depp testifying there, likely a video, right?
Okay.
And you respond, that never happened. I was with them. Amber was the one acting all jealous and crazy. Do you see that?
I do.
Your Honor, I'm going to move the admission of Defendants 1903.
Any objection?
Yeah, Your Honor, we believe the first part of the that umbrella guy's tweet should be unredacted for context.
Oh,
It's hearsay. It's rank hearsay, and context
Your
is
Honor,
not necessary.
Your own approach. Of course. Take a look. All right. With that redaction, any objection?
No, Your Honor, thank you.
Okay, 1903 will be in evidence with as redacted.
Now, so you reached out to the umbrella guy in this text, this Twitter, right?
I wouldn't call it reaching.
And in fact, the umbrella guy is in Mr. Adam Waldman. Do you know who Adam Waldman is?
I have no idea.
Well, he's testified earlier that the umbrella guy.
That he what? He talks to
her. This event where you texted, Your Honor, yeah, it's in, okay, good. 4 days after that, you did something pretty nasty about Elon Musk, didn't you?
I did.
Okay, thank you. So you don't like Elon Musk, right?
Objection.
Well, I don't know Elon Musk.
Overruled. Thank you.
So that was the context of that is that he had...
I didn't ask you for the context.
I apologize.
Okay. But you texted something in it. Would you agree about Elon Musk?
Yes.
Okay. Now, let's talk about your recollections here. Recollections that Mr. Depp actually drove there?
Yes.
What type of car was he driving?
An old one that was a convertible. Express the model.
All right, and your recollection was this was May of 2013?
Yes.
Okay, do you recall when in May?
Late May.
Now, you said that you spent a total of 45 minutes to an hour with Mr. Depp and Ms. Heard, is that correct?
After that, mostly Mr. Depp, but that's after checked in throughout the course of the night.
Okay. And you don't recall any of the people that were there other than Ms. Heard's sister and the security guard?
Any of their names.
Do you remember how many of them were female?
I believe it was predominantly female.
Do you remember how many males were there?
I don't. Outside of...
Do you remember what any of the other people looked like?
They honestly just seemed like youngish hipsters, like for lack of a better term. I know that all of them had stayed at Hicksville Trailer Palace. That's how they knew about the place.
Okay. So you don't recall seeing how much anybody had to drink that night?
I did not witness that.
And do you recall the use of drugs at all?
I did not witness that.
Okay. Were you sitting at any point with these people at the campfire? And when you said that that you saw Ms. Heard and Mr. Depp, and Ms. Heard was yelling at Mr. Depp,
she pulled him for a chat, and it was off towards their trailer, and their trailer?
Yes.
Approximately 75.
Okay. So where in that 75 feet did Ms. Heard pull Mr. Depp and he cowered?
20.
Okay. 20
from the campfire.
From the
trailer.
campfire.
Yeah.
So your testimony is that Ms. Heard grabbed Mr. Heard, pulled him 20 feet over.
Yes, that's what I witnessed.
And then did they go back?
I went inside the house.
So you don't know whether they returned to the campfire or they returned to their trailer?
I do not.
And do you know whether there were any disagreements or physical communications, anything of that nature at the campfire? Do you know whether Mr. Depp did anything to anybody else at the campfire?
I didn't see anything.
Okay. Do you know whether Mr. Depp grabbed anybody's wrist and asked them how many pounds of pressure it took to break their wrist?
I wasn't there the whole time.
Okay. Is it your testimony that Mr. Depp and Ms. Heard went trailer, everybody else went before them?
The rest of the people, I think about half of them had already gone to bed, and they went, it was all around the same time at the end of the night. That there might have been a couple of people that went right after them or right before, but it was all around the same time.
Okay, so your recollection is that when Amber and Johnny their trailer, that dissipated, everybody then left at that point?
Yes.
Okay. Now, how far away was your house that you were staying in from the Depp were staying in?
I'd say it was about 75 feet away.
Okay. And the next time that you saw or heard anything there in the morning and saw the broken sconce, is that
Yes,
correct?
I didn't hear anything after went to bed.
Okay. And that's the extent of your knowledge?
Yes.
Okay. I have no further questions.
All right, redirect.
Mr. Knight, how did you get involved in this trial?
I got a text from one of our old employees.
Objection, hearsay.
Don't tell us what the text said. Just how did you get involved?
I got a text from. I got a.
That's still hearsay. You're under objection.
Ruled.
Thank you. Go on, Mr. Knight.
I was asked if it was.
No,
Objection, hearsay.
Apologize.
What did you?
I got a
What
text.
did you received a text? Okay.
Yes, from an employee.
Okay. And how long had it been since you had heard from this former employee?
Approximately.
And did you contact Mr. Depp or any of his attorneys?
Objection, leading.
Overruled.
I did not.
How did you get in touch with Mr. Depp's attorneys?
Me, I.
Objection, hearsay.
Overruled.
Go on, Mr. Knight.
They reached out to me.
Okay. Sorry.
It's okay.
I don't have an objection right now.
Next question.
And how do you feel about participating in this trial?
Objection, relevance.
It's extremely relevant considering that they have accused.
Overruled.
Thank you.
How do I feel about it?
Yeah.
I'm happy to tell what I saw, and that's the extent of it. I really don't care.
Thank you very much, Mr. Knight. Nothing
All
further.
right. I assume this witness is not subject to recall. Is that correct? All right. So you're free to go. Thank you.
Thank you.
All right. Your next witness? Or is it going to be a deposition, or is it going to...
Apologies, Your Honor. Thank you. Dr. Shaw.
Okay,
Plaintiff calls Dr. Shaw.
Okay. Dr. Shaw.
Do you solemnly swear or affirm truthfully in this case or penalty of law?
Thank you, sir. All right. Yes, ma'am.
Good afternoon, Dr. Shaw. Can you please state your name for the record?
My name is Richard John Shaw.
Shaw, can you please describe your educational background?
I'm a psychiatrist. I went to medical school at the University of London in England. I went straight, that's actually the system in the British medical system. I did 2 years of preclinical training and then 3 years of clinical work with patients. Following that, I moved to New Zealand to do an internship. It was an internship in neurology, medicine, surgery, and psychiatry in New Zealand, and I did a year of psychiatry residency training. Excuse me. And following that, I did a residency in adult psychiatry at the Albert Einstein College of Medicine, which is in New York, in the Bronx. I also did some subspecialty training in family therapy, couples and family therapy as in my 4th year. And after that, I moved to California, Stanford. I studied at Stanford. I did a fellowship in child and adolescent psychiatry, and I've been at Stanford pretty much since then.
Your current position.
I'm a professor of psychiatry in the Department of Psychiatry at Stanford. I also run what's called the Psychiatry Consult Service at the Children.
What, if any, professional certifications have you received?
I have what's called board certification in adult and general psychiatry. I did psychiatry and neurology in 1991. And then I obtained subspecialty board certification in child and adolescent psychiatry in 1993.
Are organizations in the field of psychiatry?
Yes, I am. I'm a member of the American Academy of Child and Adolescent Psychiatry. I'm also a member of the Academy of Consultation Liaison.
How long have you been practicing psychiatry?
If you include my training in psychiatry residency in the US, that would be since...
Is that approximately 35 years?
Yeah, I think so.
What percentage of your practice involves treating patients?
Yeah, approximately time is working with patients. I work in the pediatric hospital, treating a combination of mainly children and adolescents with but also working with parents of children who have severe medical conditions. I also consult to the emergency room, and we evaluate patients who show up with suicide attempts and other serious situations.
What does the remaining quarter of your practice entail?
As a professor, I have to do a number of academic activities. So I do research. I do a lot of teaching as residents, medical students, and fellows in psychiatry. I do some medical students and fellows in psychiatry. I do some administrative work. Yeah, so it's a pretty diverse.
Story a little bit about your research and academic work.
Medically fragile children. So I've developed some interventions and developed trauma symptoms. So I've developed some interventions to try to help parents, provide support and treatment to reduce their symptoms of trauma.
Have you published articles of expertise?
Yes, I have. I've published approximately 70 or probably closer to 80 peer-reviewed manuscripts in different scientific journals. I've also published a number of book chapters on various topics, approximately 30. And I have published 3 textbooks into a second edition on topics that are related to my area of expertise. And one of them actually is about the treatment of PTSD in parents of premature infants.
Have you published a book through the APA?
Actually, all of those books were published through the APA, the American Psychiatric Association House, and that's been my publishing company.
What is the APA?
The APA, the American Psychiatric Association, not to be confused with the association, is a professional organization that represents psychiatrists in the US. The last time I looked at this, I think there's about 37 or 38,000 members. The APA has many different roles. One of it is advocacy in psychiatry in the US, but it also has an important role in terms of education, an annual scientific meeting every year in which psychiatrists will present their research. It publishes a number of journals in the field, and fairly frequently it publishes.
What ways are you involved with the APA?
Well, I mentioned my publishing. I last presented in 2021 during COVID. It was virtually, but on the topic of group therapy for parents with. I follow the APA and their various guidelines. I think it's a really influential and important. Follow the APA and their various guidelines. I think it's a really influential and important institution.
Going back to credentials, what, if any, professional awards have you received?
I've been given several teaching. The American Academy of Child and Adolescent Psychiatry that I mentioned honored me with an award several years ago. I don't remember.
Have you given any public presentations in the field of psychiatry?
Yes, that's part of our work as an academic psychiatrist is to lecture. So I present fairly frequently at annual scientific meetings, as I mentioned. I've been invited to give grand round presentations at centers, including University of Pennsylvania and Harvard. So that's just part of our role is to try to educate our colleagues about our work.
Expert in the field of psychiatry before?
Yes, I have.
On how many occasions?
I would estimate, in terms of deposition, approximately 50 times in the past 15, 20 years.
What type of cases did you testify as an expert in?
They're pretty varied. So some of them have been medical. I've also done a number of cases evaluating victims who've been subject to physical or sexual assault or trauma.
What work were you asked to do in this case?
My role in this case was to give my opinions about the testimony and opinions you heard from yesterday morning.
And what work have you done to form your opinion?
I was present yesterday in court listening to his testimony. Viewed his depositions. He had 2 depositions earlier this year, and I watched those depositions. I've also testimony by Mr. Depp's psychiatrist, Dr. Blaustein, by his physician, Dr. Kipper, and nurse, Debbie Lloyd. I've reviewed depositions by the therapists involved in this case, including Dr. Banks, the relationship consultant, Dr. Cohen, who was Ms. Heard's therapist, and I think Dr. Anderson, who I think provided some couples therapy. The medical records of Dr. Kipper and Dr. Blaustein, and information that has been talked about here.
Thank you. Your Honor, at this time,
All right. So any objection?
No objection, Your Honor.
All right, so he'll be moved as an expert. Thank you.
Dr. Shaw, you testified that you observed Dr. Spiegel's testimony yesterday.
Yes, that's correct.
And to reorient the jury, can you please generally describe the main areas in which Dr. Spiegel testified?
Objection, Your Honor. They heard what he testified to. What's his opinion?
All right. Foundation to reorient them.
That's okay. We can move forward.
Okay. Do you have an opinion of Dr. Spiegel's testimony?
Yes, I do.
And what is your?
I have a couple of primary opinions. The first is that my opinion is that he violated the ethical principles that are outlined in the Goldwater Rule. Opinions about Mr. Depp, specifically with relationship to personality traits and his cognitive abilities. My primary opinion would be that Dr. Spiegel's opinions were unreliable and that he had insufficient.
All right. You're going to approach?
Yeah. Dr. Shaw, you mentioned the Goldwater Rule. What led up to the publication of the Goldwater Rule?
Rule came about in response to an incident that occurred during the 1964 presidential. Senator Barry Goldwater was running as a Republican candidate, and there was a magazine called Fact Magazine that started a campaign to edit Senator Goldwater, and they obtained a mailing list from the AMA and sent out a single survey question to 12,000 psychiatrists in the US, asking if they felt that Senator Goldwater was fit to run for office. And about 2,000 responded, 1,000 of whom expressed very negative opinions about Senator Goldwater and made comments such as, for example, he was a megalomaniac, schizophrenic, that he had narcissistic personality disorder. And as a result of that, he was replaced as a candidate to sue Fact Magazine for defamation of character. And he was successful in that lawsuit. And in response to this, the American Psychiatric Association, that I think was really concerned about how psychiatry was being represented and statements psychiatrists were making about someone they had never met, issued the Goldwater Rule. And the main premise of the Goldwater Rule was that it was improper for a psychiatrist to render about a public figure unless they had personally and closely evaluated them.
What justifications did the APA provide, other than the ones you mentioned, for?
They wanted to make sure that psychiatric illness wasn't being stigmatized. They wanted to individuals weren't defamed by the psychiatric profession, since I think the public in general, when a psychiatrist speaks out publicly and expresses an opinion, a psychiatric opinion, people generally like to take that seriously, and the APA wanted to make sure that those opinions were credible and could be relied upon.
Have there been any updates?
Yeah, since 1973, which was when the APA, they called Annotations in Psychiatry, in which the Goldwater Rule has been better defined and expanded to some degree. 2017, in this publication, the APA reasserted that it was not ethical to provide a professional opinion about someone who had not been evaluated personally by that psychiatrist, that it was unethical to provide an evaluation from that individual. They also sort of really kind of defined what a professional opinion, and how they defined it is that an opinion that a psychiatrist expresses about someone's speech, behavior, or any characteristic about that person, if that opinion is made using the expertise, experience, and knowledge inherent in the practice of psychiatry, that is considered a professional. It might include making a diagnosis or not making a diagnosis. And the other, I think, a couple of important things about that 2017 document, APA specified that if a psychiatrist is to give an opinion about someone, about the diagnosis or personality, that they have to follow an appropriate methodology. They have to do an evaluation that follows the standard practice of a psychiatrist here in the US. If they don't do that, they are considered to be, affecting the integrity of both the psychiatrist and the psychiatric. And this revision of the Goldwater rule definitely received a lot of support. The president of the APA at the time stated that breaking the Goldwater rule was irresponsible, stigmatizing and definitely unethical. A very strong statement from the president of the APA.
What other medical organizations have weighed in on this issue?
Yeah, the number of organizations have their own sort of rule. The American Medical Association, that represents physicians in the US, has an annual meeting, and they're full of ethical and judicial affairs. And they had a meeting in 2017 in Honolulu, and they came up with their own statement about the issue of whether physicians can provide evaluating somebody. And their opinion was that physicians should refrain from giving a psychiatric diagnosis about any public figure, including people in the media.
Are there exceptions to the Goldwater rule?
There are exceptions, yeah. And I think Dr. Spiegel had a lot to say about this yesterday. Couldn't express an opinion without evaluating someone. It sort of made the whole specialty of or role of experts in the court sort of null and void. But there are exceptions and situations in which can give testimony in court. So one good example would be if there was a medical malpractice case, or if there was a case that involved suicide and the courts wanted to find out whether the psychiatrist had followed appropriate practice, the expert can review medical records and can, provided those records have sufficient information, for example, about the diagnoses, about the treatment, about how the patient was responding or not responding to treatment.
Did you form an opinion about whether Dr. Spiegel complied with the Goldwater rule?
Well, my opinion is that he did not. He expressed a number of professional opinions to Depp that we heard about yesterday. And again, he did so without, he did not follow the guidelines of the APA in the 2017, not follow the guidelines of the APA in the 2017 revision, where it was considered important that there be that expert to give an opinion. So I would definitely felt that his conduct, unfortunately, did violate the Goldwater rule.
And specifically, what opinions of that Dr. Spiegel gave yesterday do you feel violated the Goldwater rule?
Yeah, I think that, well, there were sort of two primary ones. Was that Dr. Spiegel had professional opinions about Mr. Depp's personality, and he talked a lot about how he believed that he had narcissistic personality traits. So, and he also, talked a lot about narcissistic personality disorder. So, narcissism in the Diagnostic and Statistical Manual, it's called the DSM-5 for short. It's a diagnostic manual published by the APA.
Okay. Go ahead, Dr. Shaw, please continue.
Sure. So I was just talking about Sure. So I was just talking about narcissistic personality disorder in the DSM-5. So the diagnostic criteria for that are, every word about this, but essentially it's a pattern of grandiosity, a need for admiration, that's demonstrated by that person since young adulthood. And the DSM-5 has 9 specific criteria, and for someone to meet the diagnosis, you have to meet criteria. And so when, as a psychiatrist, we're trying to make a diagnosis of any personality disorder or any diagnosis in general, professional guidelines would dictate that we would do a very careful diagnostic interview. And there are actually interviews specifically written to assess this. It's also possible to have the individual fill out questionnaires. There's something called the Narcissistic Personality Inventory. This is a 40-item that taps into various components of narcissistic personality disorder. And it's also possible to get psychological testing, like you heard about in reference to one of the other experts here. So with all of this information, including collateral information from work colleagues, information of that sort, it is possible to come up with a diagnosis of narcissistic personality disorder. In the case of Dr. Spiegel, he had none of this information, even though he came out and stated with what he described as a degree of medical certainty. Mr. Depp had narcissistic personality traits. And if you remember somewhat towards the end of his testimony yesterday, since he couldn't provide any documentation from the medical record about narcissistic personality disorder or narcissistic personality traits, he was is referred to a lot in his testimony as record evidence. So information that he obtained from depositions, from text messages, from emails, whatever. And so he was asked to give, I think, 5 evidence that would make it seem like Mr. Depp met criteria for narcissistic personality traits. And I'll just mention a couple of them, just to illustrate my opinion, is that really hold together. So he stated, for example, that one of the criteria for narcissism is narcissistic disorder is a sense of entitlement. And the example Dr. Spiegel gave is that he believed that Ms. Heard married him for his money. So clearly, sense of entitlement, psychiatry perspective, that's very different from a belief that someone wanted you for your money. A second example that was given was that to give an example of how Mr. Depp had shown that he was envious of others, which is another criterion for narcissistic personality disorder. And the example that gave is that Mr. Depp was jealous of Ms. Heard because he believed she was having an affair with Mr. Franco. In terms, as a psychiatrist, there's a big difference between being envious and being jealous. As a psychiatrist, when I think about envy, I think about somebody wants someone else has, and it makes them feel bad.
Your Honor, I think this is going beyond his investigation.
He's giving his opinion as to how Dr. Spiegel violated the Goldwater rule with respect to his testimony about narcissistic personality traits. Okay. Okay, and you mentioned 2 major examples. What was the second one?
The second one was confusing being envious with being jealous.
Dr. Shaw, I mean, you mentioned 2 major examples of ways Dr. Spiegel violated the Goldwater rule. What is the second?
Oh, sure. So the other big category had to do with Dr. Spiegel's evaluation of Mr. Depp's cognitive abilities. And his general opinion was that Mr. Depp had deficit in his attention, in his processing speed, that he had word-finding difficulties. Again, Dr. Spiegel did not evaluate, and the information that he relied upon, there were two pieces of information. The first was that he watched a very long deposition the day after I think he had flown back from London to the East Coast. And he made observations of behavior in that deposition and felt that he could opine or give an opinion about processing speed and other cognitive aspects. He also made reference to something you heard about yesterday, this thing called the mini mental status examination. This is a brief screen for functioning that is often done. And he testified that Dr. Blaustein had administered the mini mental status examination. Although, from the records, all we know is that...
Objection, Your Honor.
I'll sustain the objection.
Dr. Shaw, without going into Dr. Blaustein's record, what information provide?
Objection, Your Honor. It's beyond the scope of his designation.
Overruled as to that limited question.
Yeah, so the mini mental status is, it's a series of about 10 or 11 questions and tasks that someone completes, and you get a score out of 30. What Dr. Spiegel testified was that not recall 3 words after 5 minutes. And he used that as an example of Mr. Depp having cognitive deficits that he specifically addressed alcohol and substance abuse. And he really did not have sufficient information. I liken a mini mental taking someone's temperature. If it's elevated...
Objection, Your Honor. I think it's going beyond designation.
I'll sustain the objection.
Okay. Now it's probably a good time for a break.
Okay. All right, ladies and gentlemen, I know you had a break, but we didn't. So we're going to go ahead and take our afternoon break for 15 minutes. Do not discuss the case and do not do any outside research, okay? You can stay right there, Doctor. All right, you're excused for the 15 minutes too, sir, Doctor. Okay, we'll come back at day. Okay. Thank you. You may be seated. All right, your next question.
Thank you. Dr. Shaw, is the Goldwater rule limited to diagnoses?
It includes all professional opinions.
Do you agree with Dr. Spiegel that the Goldwater rule doesn't apply to expert witnesses?
I don't agree.
How could Dr. Spiegel express an opinion without violating the Goldwater rule?
This has actually been a topic that's been written and published about. I want to give testimony about a matter without interviewing someone. And there's certain sort of ways that it should be framed. So if, Dr. Spiegel was testifying about the report that Mr. Depp was unable to recall these 3 objects. What he could have done is said that I have not personally examined Mr. Depp, so I can't speculate about his cognitive state or ability to function. However, it is possible that someone who's not able to recall 3 objects could have issues related to substance use, his opinion was. However, what he should have done in expressing his opinion is then have followed up to say that in order to really establish whether these relevant and significant cognitive deficits, Mr. Depp should have had psychological testing to establish the nature of these deficits. And that there are other potential explanations for these findings. So, for example, it's possible that Mr. Depp...
Objection, Your Honor. He's now going.
I think he's just opining as to, or is responding to Dr. Spiegel's testimony yesterday.
No, he's opining as to what Dr. Spiegel could have said, but it's past the, whether he, about the...
All right, move on.
Okay. Who's qualified to give an opinion about cognitive deficits and processing speed?
It would have to be someone who conduct the type of neuropsychological testing that I was mentioning. You can't establish the presence of cognitive deficits without a battery of tests.
Objection, again, this is beyond the Goldwater rule.
Overruled.
You can't establish cognitive deficits without appropriate neuropsychological testing, and that can only be done by a psychologist or neuropsychologist. So a psychiatrist like Dr. would be giving an opinion outside of his area of expertise if he gave an opinion about cognitive deficits that required psychological testing to be further evaluated.
Dr. Spiegel yesterday testified about the practice of forensic psychiatry. Do you recall that testimony?
Yes, I do.
What is forensic psychiatry?
Forensic psychiatry is a specialty of psychiatry that matters on the intersection between psychiatry and the law. So, for example, what we're doing today is forensic psychiatry, where a psychiatrist comes into court and gives an opinion about, may come to an opinion.
Are there professional standards that govern the practice of forensic psychiatry?
Yes, there are.
And what organizations have issued those standards?
Primary organizations that has issued guidelines about the practice of forensic psychiatry is called the American Academy of Psychiatry and the Law. This is an organization of psychiatrists, and it has published guidelines about what constitutes an ethical and sound practice assessment and providing a psychiatric opinion. So this guideline, I think was published in 2015, actually contains myths that are consistent with the Goldwater rule. So, for example, it states that for a forensic assessment to be done, there has to be informed consent, a very thorough, comprehensive evaluation that would include reviewing past records, past psychiatric history. It would include doing what's called a mental status evaluation of someone's mood, cognition, things of that nature. And the guidelines do state that it is or permitted to provide an opinion without an evaluation, but if you're going to do that, there's some things that you have to really make clear in your opinion when you express. And the first is that you have to acknowledge the limitations of your opinion and not, like Dr. Spiegel, say that his opinion was held with a degree of medical certainty. You have to explain what's missing, what data you did not have that you were not able to rely upon in coming to that opinion. You also have to talk about the need to come to that opinion. And even though these guidelines say it's permissible to do this, the text, I think, not fully in support of psychiatrists doing this. So their statements are that opinions rendered without a proper database to rely upon to make diagnoses and give opinions, professional opinions, is questionable and not generally recommended.
Opinion about Dr. Spiegel's testimony with respect to these practice guidelines?
Yes, I did.
And what is your opinion?
Well, my opinion is that he did not follow those guidelines. So did not have consent. He did not do even a basic evaluation of Mr. Depp. When he gave his opinions, as I just mentioned, opinions that he had to a degree of medical certainty, and he did not make any statements about what other additional information he would have wanted to make that. For example, when asked about should neuropsychological testing be performed, he said most patients don't have access to that, which is not at all true. I mean, every medical school has neuropsychologists that can do testing. So I think that was an unfortunate statement. So those are the primary ways in which the Goldwater Rule was violated, and the practice guidelines were not adhered to.
Dr. Shah, yesterday Dr. Spiegel was talking causation. What is the difference between correlation and causation?
Objections? It's not in this designation.
It is. We can approach and I can show you.
Okay. All right.
Go ahead, Dr. Shah.
The difference between a correlation and causation. Correlation is a statistical analysis of a relationship between two different factors. In Spiegel's testimony, he talked about, there being a correlation between opinions he had about Mr. Depp, his narcissistic personality traits, his substance abuse. So a correlation doesn't say anything about whether or not these factors caused that, the behavior he was discussing. Perhaps one of the easiest ways I could describe this difference between correlation and causation is if we look at the issue of measles, if you'll bear with me. So there's a correlation between and catching measles. Now we know that measles is not caused by being young. Measles is caused by a virus. But young children have not been exposed to the virus at a higher rate of measles. So the difference statistically is, the difference is between causation and correlation is illustrated by that example. So put this as if, if we had 100 people in a room, just bringing it back to the issue of IPV that Dr. Spiegel was testifying about. Let's say we had 70 people, all the risk factors for IPV, and 30 people who had no risk factors for IPV. So what can we say about those 70 people? We can't say that any single has perpetrated IPV, even though they may have all the risk factors. And if we look at the 30 people who have no risk factors, we also can't say whether or not they have IPV. So the actual presence of risk factors for IPV that Dr. Spiegel was talking about, they say absolutely nothing about what happened in this case.
Thank you, Dr. Shaw. Nothing further.
All right, cross-examination.
Good afternoon.
You're not offering any opinion as to Mr. Depp's psychology, correct?
That's correct.
And you testified a lot about the Goldwater rule. You know of no case where an expert has been excluded from testifying based on the Goldwater rule, correct?
I don't know of cases that's possible, but I don't know personally about one.
And you, before this case, you've never offered an opinion on the Goldwater rule before, correct?
That's correct.
And Goldwater rule, correct?
I have not.
And you've never given a presentation on the Goldwater rule, correct?
I have not.
And you've never been on any committees regarding the Goldwater rule, correct? Okay. And you agree that you've testified that there are exceptions to the Goldwater rule about the subject, right?
Yes.
And you understand that Dr. Spiegel requested to meet with Mr. Depp twice, but Mr. Depp declined, correct?
I'm aware of that.
And Dr. Spiegel nation and at trial yesterday that he did not meet with Mr. Depp, right?
Yes.
Okay. Can we put up defendant 4? Dr. Shaw, have you seen the opinions of the Ethics Committee on the Principles of Medical?
Yes.
Okay. And if you could turn to 79 of the PDF, psychiatrists have also argued that the Goldwater rule is not sound because psychiatrists are sometimes asked to render
Objection,
opinions.
hearsay.
He's an expert. Without conducting an examination of an individual, in particular, in certain forensic cases and consultative roles. This objection attempts to subsume the rule with its exceptions. What this objection misses, however, is that the rendering of or an opinion in these contexts is permissible because there is a court authorization for the examination or an opinion without examination. And this work is conducted within an evaluated parameters for how and where the information may be used or disseminated. You see that?
I do, yes.
And this court authorized Doc's case, correct?
Yes.
Okay, thank you. I have nothing further.
All right, redirect.
Dr. Shaw, Mr. Nadelhoff just asked you about the court authorization of Mr. Depp's evaluation. Twice denied Ms. Heard's request for an evaluation of Mr. Depp.
I heard that yesterday in testimony, yes.
Okay, thank you. Nothing further.
All right. Thank you. Either have a seat or you can leave. Thank you. Your next witness. All right.
Please state your name and address for the record.
Jennifer Howell, Los Angeles, California.
Foundation.
I run the Art of Elysium, CEO of the Art of Elysium.
Let me just go back. Now, you've indicated that Whitney lived with you from January May 2015 to April 2016. Are you absolutely certain about those dates?
I am certain. Yes, she came at different periods, but all of her stuff moved out of my house April 2016.
And I'm sorry, did you say you were 100% certain of that? Ms. Hall, could you answer my question?
Go back to Amber and Johnny's at different points that she was still living with me during that time.
The question I asked, because you were talking at the same time Ms. Vasquez was I believe that you said you were 100% certain of those dates. Is that correct?
Same with me.
All right.
Oh, you previously testified that you were the CEO. Is that correct?
That is correct.
And are you still currently in that position?
Yes, I am.
And how long have you been the CEO for Art of Elysium?
I am the founder of the organization. We did our first workshop in August of 1997, filed the legal paperwork in February of 98 to set up as the beginning of the charity.
Ms. Howell, when did you first meet Amber Heard?
At the Pineapple Express premiere, I met she and her sister Whitney.
Do you remember approximately what year that was?
I believe it was around 2008. It was the LA premiere. I think there was probably multiple premieres, but it was the Los Angeles premiere of Pineapple Express.
Was Ms. Heard there with Mr. Depp?
No, this was long before. I was a guest of James Franco and Amber movie. And so I met she and her sister at to be specific, at the after party of the premiere.
Did Ms. Henriquez for Art of Elysium at some point?
Yes, she did.
What year did Ms. Henriquez begin working with Art of Elysium?
I believe it was in 2014. I believe it was leading into the year Amber was receiving the award.
And what was Ms. Henriquez's position at Art of Elysium?
Art salon manager, director.
Does Ms. Henriquez still work for Art of Elysium? When did that end?
Oh, 2015, I believe.
Each time you saw Mr. Depp, see him doing any illicit, illegal drugs?
Never.
Did you ever see him consuming excessive amounts of alcohol?
Objection.
Did you ever see Mr. Depp appear intoxicated?
No.
Did Ms. Heard ever show you photographs of depicting on her face or body?
No.
Did Ms. Heard ever tell you that Mr. Depp was abusive towards her?
No.
Mr. Depp paying your legal fees, Ms. Howell, for this deposition and the testimony you've provided in the UK action?
He is not.
Who is?
Myself.
Towards Ms. Heard?
None at all.
Ms. Howell, do you recognize this check as the check that the Art of Elysium, on behalf of Ms. Heard, for a donation, an anonymous donation of $250,000?
Yes. Yes.
I believe you testified previously that you understood the anonymous donor was Elon Musk. Is that true?
Yes.
If I could please have Exhibit 4 brought up. And for the record, it's based on 22 through 29.
What for?
Do you recognize this document, Ms. Howell? And if you need to scroll through the 8 pages, feel free.
Can you scroll down? Yeah, I recognize that.
And what is this?
That an email, I believe, I sent to Whitney.
Scrolling up to the first page of this attachment, who is
Paraso?
Sure, Paraso.
He is one of my oldest friends in Los Angeles who has served as a board member of the Art of Elysium and is confidants here in LA, kind of for the course of my career.
Third page of this exhibit. Thank you. This is an email, Ms. Howell, that you sent to Whitney Henriquez on or about Tuesday, July 28th, 2020 at 11:02 a.m.
It is.
This is a true and accurate copy of an email exchange that you sent to Ms. Henriquez?
Yes, I believe I'm the one.
And then did you forward this email exchange and the attachments to Marcel Parasal?
Yeah, I asked him to keep it for me.
Why did you send this email and letter to Ms. Henriquez?
Because I've struggled very much with what to do in a situation that I love someone who and I know that they're doing it because they're trying to protect their sister, and I'm trying to protect her, and I'm just trying to get her to do the right thing, which is tell the truth. It's the only thing that can help everybody involved in this case.
Ms. Howell, do you recall submitting a witness statement in the United Kingdom?
Yeah, they basically just called to verify the witness statement that was submitted previously.
And do you recognize this document to be the witness statement and the declaration that you submitted in the UK? And if you want to scroll down to look at it.
Yes, I recognize it.
And at the first page, do you see on this document?
January 13th, 2021.
And is this document a true and accurate copy of the declaration that you submitted proceeding on or about January 13th, 2021?
Yes.
And are all the statements in your UK declaration accurate?
I mean, yes, I signed it, yes.
All right, let's pull up what I believe was Depp Exhibit 9. It's been marked as Depp Exhibit.
Exhibit 9.
So, Ms. Howell, earlier you were shown this document. Scrolling to the end of it.
Can you go? Okay.
There.
Mm-hmm.
Did Mr. Waldman assist you in drafting this email?
Absolutely not.
Did you drafting this email?
About writing an email? No. I did that on my own accord.
Did you speak with Mr. Waldman at all about contacting the ACLU?
I do not recall having a conversation with him about that.
And Ms. Howell, you testified earlier that you received a check from Fidelity Charitable in January.
I don't know if I said the date, but yes, I received an anonymous donation from that check that was submitted. Whatever it's on there, I just don't off the top of my head.
And you testified that there was a letter sent along with that that said that it was on.
Yes. Richard, I was guaranteed 20 minutes with him after being attacked for 3.5 hours
yours by your side the last time. So I am going to stick by what I was told entering this and what your side agreed to.
All right, your next witness.
Your Honor, Mr. Depp calls Candy Davidson Goldbraun, who is the Children's Hospital of Los Angeles.
All right, and that's by deposition, is that correct?
Yes, Your Honor.
Okay.
Goldbraun, is it your understanding that you're here to testify today on behalf of the hospital?
Correct. Yes.
Okay. So as of June 2018, had any payments been made by Ms. Heard to the Children's Hospital in connection with the $3.5 million pledge, aside from the original $100,000 date in August of 2016?
Yes, there was a payment, a gift on January 9th of 2018.
And is that gift that you're referring to on Ms. Heard's behalf?
By Ms. Heard.
Okay, and what are you basing that statement on?
By the check that we received, Fidelity Charity that came to Children's Hospital.
What is this document?
The letter to Mr. White from myself inquiring about further installments on the pledge that had not been fulfilled.
And why did you write this to Mr. White on June 14th, 2019?
I was trying to figure out if there were any other payments coming from Mr. White to fulfill the pledge, because Children's had not received any other correspondence from him.
And what is this document?
It is a letter to from myself on behalf of Children's Hospital Los Angeles, inquiring about additional gifts. Pledge.
This letter appears to be directed to
in the Children's Hospital Los Angeles records. Jody Gottlieb was.
Why did you send this letter to Ms. Heard? Why did you send this letter to Ms. Heard and Ms. Gottlieb?
I was trying to see if the pledge filled or not.
In your experience, is it common practice one paragraph state that they wish to remain anonymous, and in the very next paragraph they wish to remain anonymous, and in the very next paragraph identify themselves?
Yes.
Paragraph identify themselves?
Yes.
That is common?
It is common in anonymous publicly, but allow the charity to know who they are.
Between June 2018 and the dates on which you sent the letters to Ms. Heard in June of 2019, were any additional funds received from Ms. Heard?
No.
Okay, so as of 2018, a total of $250,000 had been received as far as the Children's Hospital is concerned from Ms. Heard. And that was the same amount that was later in June of 2019. Is that accurate?
Correct.
As of the date of this deposition, March 3rd, how much in total has Ms. Heard donated to the Children's Hospital?
For this particular guest? For the lifetime?
From 2016 to present.
$250,000.
Ms. Goldbraun, you recall we were speaking about this letter a few minutes ago? All right, and this was a letter that you sent to Ms. Heard, correct?
Correct.
Did you ever get a response to this letter? As of October of 2018, how much money had Ms. Heard directly donated to the children?
$250,000.
As of March 30th.
I'm sorry, I didn't hear the end of that.
You said October 2018.
Correct.
Okay, yeah. $250,000.
30th, 2019, how much money had Ms. Heard directly donated to the Children's Hospital?
250.
What is your understanding of the length of time over which Ms. Heard pledged the gift of $3.5 million to Children's Hospital?
There was no date arrangement with Ms. Heard to have this pledge paid off in a particular time.
The rest of the $3.5 million in 2 years, or $0.5 million in 2 years or 5 years, would Children's Hospital welcome that?
CHLA welcomes every that comes its way.
Has Amber Heard's pledge of the $3.5 million to Children's Hospital expired, to your knowledge?
Not expired.
All right, thank you. Your next witness, or?
Your Honor, I think we've concluded our witnesses for today. We will.
Okay, all right, ladies and gentlemen, that'll be the end of your day for today. Again, do not do any outside research, do not discuss the case with anybody, and we'll see you tomorrow morning at 9 a.m., okay? Thank you. You want to have a seat for just a moment because we do have a few proffers going to be done. Just for the record, we talked about it earlier. I will charge the 30 minutes extra time for today so we can stay on time.
Understood, Your Honor.
Okay. All right. And I believe, Mr. Rodenborn, you had some proffers you wanted to do for testimony.
We did,
for
Your
the,
Honor,
for the record.
testimony in a few exhibits.
Mr. Nadelhoff, if you want to proffer testimony for the record as to the testimony that the court has sustained objections.
Your Honor, it's a box here, so I just
All right, that's fine. You can stay there as long as you stay close to the microphone. I appreciate it.
And Your Honor, what I will do is I'll explain what we're proffering the evidence for, and then we have copies.
Good.
Which I'll provide to you. Electronically, or I don't have another copy for you right now, but we'll provide.
That's fine. Go ahead. Yes, sir.
Okay. Your Honor, for Laurel Anderson, on March 31st, defendant attempted to designate certain portions of the deposition testimony for trial of Dr. Laurel Anderson, a clinical psychologist who worked with Ms. Heard and Mr. Depp. Dr. Anderson testified in the therapy session by Mr. Depp that he hit her in the head, had her hair pulled by Mr. Depp, kicked her in the leg, and that Mr. Depp gave Ms. Heard bruises. Ms. Heard also reported that Mr. Depp was the first to initiate any violence. She hid in a bathroom to protect herself from Mr. Depp. Ms. Heard also reported to Dr. Anderson that Mr. Depp threw a phone at her on May 21st, 2016, hit her, and held her hair. Ms. Heard to Dr. Anderson that she was a victim to Mr. Depp's abuse. The testimony is contained in Dr. Anderson's deposition transcript, which is Exhibit A. The court also excluded records in Mr. Depp's therapy sessions and a treatment summary, which are Exhibits B and C. Mr. Depp objected to Dr. Anderson's testimony as described in medical records, stating that they were hearsay and to any exceptions, including statements for purposes of medical treatment. The court sustained the objection on the ground that the testimony and exhibits were hearsay. For Dr. Kipper, on March 31st, certain portions of the deposition testimony for trial of Dr. David Kipper, Mr. Depp's physician. Dr. Kipper testified Ms. Heard voiced concerns of Mr. Depp's behavior while on drugs and alcohol, that Ms. pushed Ms. Heard while he was attempting detox on his island, and that she found lots of cocaine in February 2016. Dr. Kipper also testified he told Mr. Depp to, quote, bury the dragon Mr. Depp has inside him. This testimony is contained in Dr. Kipper's deposition transcript, which is Exhibit D. Dr. Kipper also testified about an email he wrote explaining Mr. Depp's deal. Dr. Kipper wrote to Mr. Depp's sister that Mr. Depp had fundamental issues with anger, romanticized the drug culture, and had no patience if his needs were not met. This email is Exhibit C. Exhibit E. Mr. Depp objected to Dr. Kipper's testimony and the email stating it was hearsay, that it did not fall into any exceptions, including statements for purposes of medical treatment. The court sustained the objection on the ground that the testimony Deborah Lloyd. On March 31st, 2022, the defendant attempted to designate certain portions of the deposition testimony for trial of Debbie Lloyd, Mr. Depp's nurse. Ms. Heard voiced concerns about Mr. Depp's behavior while on drugs and alcohol, and that Mr. Depp worked himself up into a rage and was trying to fight Ms. Heard while he was attempting detox on his island. This testimony is contempt, which is Exhibit F. Also, Ms. Lloyd kept nursing notes on these issues that she testified to, which is Exhibit G. Mr. Depp objected to Ms. Lloyd's testimony, and portions of the nursing notes did not fall into any exceptions, including statements for purposes of treatment. The court sustained the objection on the ground that the testimony and portions of the nursing notes were hearsay. On March 31st and April 1st, 2022, the defendant attempted to designate certain portions of the deposition testimony for trial of Ms. Filati. Ms. Filati testified that Ms. Heard reported to her on December 16th, 2015, that Mr. Depp headbutted Ms. Heard in the forehead. This also was contained in Filati further testified that Ms. Heard reported being freaked out after the December 2015 incident and testified to text messages between herself and Ms. Heard, or exhibits I, J, K, L, and M. Ms. Filati also testified that on May 21st, 2016, Ms. Heard reported that Mr. Depp with IO till it right. Ms. Filati testified to text messages reporting this as well, which are contained in Exhibit N. The testimony objected to Ms. Filati's testimony, portions of the nursing notes, and the text messages referenced stating it was hearsay. Testimony, portions of the nursing notes, and the text messages referenced stating it was hearsay that did not fall into any exceptions, including statements for purposes of medical treatment. The court sustained the objections on the grounds that portions of the nursing notes and the text messages were hearsay. Amy Banks, Dr. Amy Banks. On April 29th, 2022, the defendant attempted to designate certain portions of the deposition testimony for trial, a clinical psychologist and relationship consultant who worked with Ms. Heard and Mr. Depp. Dr. Banks testified that in therapy sessions, Ms. Heard reported that Mr. Depp attacked her physically, including by hitting her. Dr. Banks also testified that Ms. Heard reported that Mr. Depp cut his finger off and burned himself with a cigarette. Dr. Banks also reported that Ms. Heard told her that Mr. Depp initiated the violence, and Mr. Depp did not object to the characterization of the violence. Finally, Dr. Banks testified that she believed Ms. Heard's accounts of the violence and that Ms. Heard was a victim of domestic abuse. This testimony is contained in the deposition transcript, which is Exhibit P. Mr. Depp objected to providing improper expert opinion. The court sustained the objections on the grounds that the testimony about the abuse was hearsay and that Dr. Banks' testimony that Ms. Heard was a victim of domestic abuse was improper expert. Connell Cowan. On April 29th, 2022, the defendant attempted to designate certain portions of the deposition testimony for trial of Dr. Connell Cowan, a clinical psychologist. Dr. Cowan testified that in the therapy session, Ms. Heard reported abuse by Mr. Depp, including text messages and medical notes, where Ms. Heard reported in December 2015 that, quote, is contained in Dr. Cowan's deposition transcript, which is Exhibit Q. It is also contained in Dr. Cowan's medical notes in Exhibit R at Depp 3 and is contained in text messages that are Exhibits S and T. Mr. Depp objected to Dr. Cowan's testimony, stating it was hearsay that did not fall into any exception. The court sustained the objections on the ground that the testimony about the abuse was hearsay. Alan Blaustein. On April, sustained the objections on the ground that the testimony about the abuse was hearsay. Alan Blaustein. On April 29th, 2022, the defendant attempted to Dr. Alan Blaustein. Dr. Blaustein testified that in the therapy sessions, Mr. Depp also testified about the drugs that Mr. Depp was on as reported to him by Ms. Lloyd. This testimony is contained in Dr. Blaustein's deposition transcript, W and X. Mr. Depp objected to Dr. W and X. Mr. Depp objected to Dr. Blaustein's testimony regarding the cutting and burning himself as speculation, and the testimony regarding the drugs Mr. Depp was taking as hearsay that did not fall into any exceptions for purposes of medical treatment. The court sustained the objections on these grounds. Bonnie Jacobs. On May 4th, 2022, the defendant attempted to introduce into evidence the treatment note. Bonnie Jacobs, a clinical psychologist who worked with Ms. Heard. The treatment note's ruling the defendant did not call Bonnie Jacobs as a witness. Mr. Objections on those grounds. The UK judgment and for admission of the judgment itself, which is Exhibit Z. In support for her motion, Ms. Hurd argued that Mr. Depp had opened the door to the admission of the judgment by presenting evidence of damages after the date of the judgment on November. For example, Ms. Hurd observed that Mr. Depp had sought damages for losing his role in Pirates of the Caribbean 6, a movie that has not yet been made. Ms. Hurd further observed that Mr. Depp testified that the op-ed had caused him, thereby suggesting that his when reaching his opinion, which resulted in an amendment to the designation. Ultimately, the court found that Mr. Depp had not opened the door opinion, which resulted in an amendment to the designation. Ultimately, the court found that Mr. Depp had not opened the door to the admission of the UK judgment and overruled the motion, which the court did against Mr. Banya's opinions. Finally, Adam Berkovici. On May 19th, 2022, Ms. Hurd attempted to call Adam Berkovici, who is an expert in the policing and Los Angeles Police Department policing of domestic. Mr. Berkovici would have testified to his qualification, supplemental and rebuttal disclosures dated March 31st, 2022. Mr. Berkovici spent 30 years with the LAPD, retiring in 2012 at the rank of lieutenant. He has extensive experience as a patrol officer, uniformed watch commander, both as Sergeant 2nd and Lieutenant 1, along with multiple assignments as an officer in charge, Lieutenant 2nd of specialized detective units. During his tenure with the LAPD, Berkovici held numerous positions directly responding to and overseeing subordinate officers' responses to the domestic violence calls for service, including as a patrol officer, supervisor, watch commander. And actually this, Your Honor, is the person who prepared this prepared a longer brief of what he was going to say. I can, rather than hearing me read it all.
Any objection to that? No objection. Okay.
Okay.
That's fine. Give Jamie our copy of it. We'll make sure it becomes part of the record as well. Okay.
Thank you.
All right. Do you have any proffers, Mr. Chu, that you need to at this point?
Not at this time, Your Honor. Thank you.
All right. I think there's just a couple things I need from you. Like tomorrow, let me by the end of the day tomorrow, if I could get clean jury instruction and also the verdict forms as well. If that's been worked out, okay?
Your Honor.
Thank you. And you're working with Jamie about some exhibits. There's some that were, both sides noted that were in evidence that are not, so I want to make sure everybody gets everything cleared up. You're caught up? Okay, good. All right, just keep that going so we can get that, make sure that's taken care of. As far as time left, Sammy, today, I can give you a rough estimate for two reasons. One, you had some the breakdowns to Sammy about those. And two, Sammy wasn't here today. He had a mandatory CLE that he had to do, so I just did a rough, but it looks like the plaintiff has used about 5 hours today, and the defendant used about 1 hour and 15 minutes is what I have, okay? And again, that's a rough estimate, so don't expect them to be the same, but Sammy's going to get to it, an email this evening with the actual accurate times, okay? Anything else?
No, thank you, Your Honor. Thank you.
All right.
No, Your Honor.
Okay.
Thank you.
Have a good evening. We'll see you in the morning.
You too.